meeting of the Charleston County Board of Zoning Appeals, also known as the BZA. The board members that will hear your case tonight are myself, I'm William Ray. To my right, Mr. Truslow, Mr. Brown, Mr. Sedell, and Mr. Neal. And to my left, Mr. Nelson, Ms. Smith, and I think Jessica will be in momentarily, right? Susan? Susan, I said Susan, yeah. I said Jessica, but I meant Susan, yes. Looking dead at you. And then Mr. Jordan. Shayna. Really screwing that up. Staff members present are Wynn Carlisle, Ms. Clark, Mr. Falser, Ms. White, and Ms. Working. And to my immediate right, Mr. Kevin Hughie, he's our attorney. Because the hearing tonight is a public fact-finding meeting, we are in compliance with the Freedom of Information Act and South Carolina Code 6-29-70. 15 days prior to the hearing, an announcement was printed in the Post and Courier, a sign was posted on or near the designated property, and a notice was mailed to the applicant or the applicant's representatives to the property owners within 300 feet of the property and to parties of interest. Persons, organizations, and news media have also requested declaration of our meeting and also have been notified. Board members, meeting notes from June 1st, 2026 of the public hearing were sent to you. Are there any changes? If not, can I get a motion to approve and a second?
So moved.
Can I get a second?
I'll second.
And I got a second from Mr. Brown. Thank you. All those in favor, please indicate by saying aye. Aye. Any opposed? Very good, it carries. Minutes are approved. The Board of the Zoning Appeals is a quasi-judicial body that has final decision-making authority on the following: appeals of a zoning-related administrative decision. The BZA is authorized to hear and decide appeals only on zoning-related matters where it is alleged that there is an error in the order, requirement, decision, or determination made by the administrative official in the administration or the enforcement of any zoning-related regulations. A 2/3 votes of the quorum present is required to overturn the decision of the planning director in an appeal. Then we also have exceptions, special exceptions. A special exception is issued by the BZA authorizing a particular use of a specific location within a zoning district upon demonstrating that such a use complies with all the conditions, standards that are specified in the Zoning and Land Development Regulation Ordinance, also known as ZELDAR. The BZA must find the special exception meets all 6 of the approval criteria in the ordinance in order to grant a special exception. A simple majority is required to grant a special exception. And then finally, we have a variance. A variance is a relaxation of the BZA's regulations of the ordinance where such an action will not be contrary to the public interest and where, owing to conditions particular to the property, and will not result in the actions or the situation of the applicant or the literal enforcement of the code, would result in the unnecessary and undue hardship. And such a variance is consistent with Section 6-29-800 in the Code of the Law of the State of South Carolina, Title 6, Chapter 29. The BZA must find the variance meets all 7 of the approval criteria in the ordinance in order to grant a variance. A simple majority is required to grant a variance. Our purpose tonight is for interested parties to be heard in order to assist the board in gathering evidence that's pertinent to each case. If a member of the BZA finds a need for further information to clarify a case, the board has the authority to subpoena witnesses. It must be understood that the rules of your neighborhood or subdivision are binding, and we can take no action to negate their jurisdiction over your property. In addition to your testimony, our board has been presenting information submitted by staff, by the applicant or the applicant's agent for each case. This information is now considered to be evidence and is entered into the permanent record of the body. It is assumed to be complete, true, and accurate. In addition, we have also been presented data that has been assembled by staff for the purpose of clarifying the location for the application's effect on surrounding properties. Our board is empowered to approve with conditions, or deny special exception or variance requests. We'll also authorize to defer a case should there be a need to obtain additional information. The BZA's final decision will be mailed within 10 working days of this public hearing. It will be mailed certified mail to applicants and via U.S. mail to neighborhoods and communities of interest. If an applicant's request is approved, the applicant should contact the Charleston County Zoning and Planning Department staff to discuss the next steps in the process. Variances and special exceptions granted this evening are valid for 12 months after this meeting, and a one-year extension may be granted only if construction or development has been commenced or it has been diligently pursued. However, if an applicant's request is disapproved and the applicant wishes to appeal the decision of the board concerning the case, appeals must be made and addressed to the circuit court. South Carolina Code 6-29-820 states that an appeal must be filed by the applicant within 30 days after the decision of this board is mailed to them. Failure to file an appeal with the time limit deprives this court of its jurisdiction to hear this matter, or any matter. Because this is a quasi-judicial body, everything said in this meeting must be complete, true, and accurate. All the information provided to the BZA is considered evidence, and the board may certify contempt of circuit court if false statements were made either in writing or orally. Each person that wishes to speak to this board must be sworn in by the secretary before providing testimony to this body. In order to expedite this procedure, those wishing to present any information and evidence to this board, I ask now if you please stand, and our secretary will administer the oath.
Please stand and raise your right hand. I will say the oath and you will say I do. I swear to tell the truth and nothing but the truth. Thank you.
Thank you, Ms. Working. And thank you, everyone. I will now call each case by case number. Staff will present facts that are pertinent to each case, limited to 5 minutes. I will then call the applicant. The applicant will stand and state his or her name and current address for the record before presenting testimony that is pertinent to each case, limited to 5 minutes. I will then ask for those speaking either in support or opposition to the case, and they will follow the same procedure for identifying and addressing the court. And they are limited to 2 minutes each. The applicant will then have a chance to reply to any opposition, limited to 2 minutes. And then the BZA will make a motion to close the case to the public. Finally, the BZA will make a motion concerning the application, stating specific facts of finding and conclusion of law. And tonight, we have 2 old business cases and 7 new cases. And Ms. Working will start with our first case, which is case BZA 03-26-00955.
Thank you. The applicant and property owner, Daniel Marcus, is requesting a variance to reduce the required 25-foot rear yard setback by 4 feet, resulting in a 21-foot rear setback for a proposed swimming pool at 1470 St. Hebert Way, which is TMS number 286-13-00205 in the St. Andrews area of Charleston County. The subject property and adjacent properties to the north, east, and south are located within the planned development PD 73E Hunt Club zoning district. To the west and rear property line borders Bear Swamp Road. St. Hebert Way serves as a stub street to Bear Swamp Road. According to Charleston County records, the 0.21 acre subject property contains a single-family residence constructed in 2007. The current owner purchased the property in September 2024. The variance request reviewed at the April 20th meeting that y'all had was proposing to reduce the required 25-foot setback, rear setback by 14 feet 10 inches, resulting in a 10-foot 2-inch setback for a 17-foot 6-inch by 26-foot 9-inch swimming pool. This revised request is seeking to reduce the requested 25 rear setback by the 4 feet, resulting in a 21-foot setback for a smaller pool, a 15-foot by 6-inch by 26-foot 5-inch swimming pool. And this is the site plan showing that proposal. This plan just shows it zoomed in so you could see it more clear. The location map of showing the property in St. Andrews. The ordinance requirements from Zeldar and the plan development. This is the 300-foot radius map, the aerial map. And we posted this property on June 26th. This is the rear where the swimming pool would be located. And again, the site plans and plat. Regarding the approval criteria, we stated that it may meet 1 through 4 and 6 and 7, and that it meets 5. The board may approve of conditions, or deny the request based on the BZA's findings of fact, unless additional information is deemed necessary to make an informed decision. In the event the board chooses to approve this application, we have one suggested condition, and that's the encroachment area shall be limited to the footprint shown on the submitted site plan. And there were no public comments for this case. There was one previously for when you guys heard the case in April 20th, but that has been resolved. So, and that's all I got. Questions?
Any questions of staff?
I have one.
Yes, sir.
No, thank you for your presentation. My only question for these purposes is whether you have written approval that's documented from the HOA. It's indicated that the homeowners association approved this. Have you seen written approval from the homeowners association that say they're okay with this?
Yes.
Thank you.
Anyone else? Okay. Is the applicant present? Thank you, Ms. Working. Will you please step forward, state your name and address for the record, and please tell us why we should approve your application.
Sure. My name is Daniel Marcus, and I'm the property owner located at 1470 St. Hubert Way, Charleston, South Carolina, zip code 29414. While I believe the staff's report ultimately speaks for itself, unless the board deems it to be unnecessary, I will reiterate why the requested variance meets the 7 approval criteria set forth in the ZLDR, and why a strict application of the ordinance would create an unnecessary hardship. With respect to the first factor, the first criterion, there are extraordinary and exceptional conditions pertaining to my property because of where the house is situated on the lot. My home is situated towards the rear of the property, whereas the adjacent homes are situated more towards the front of the property, which significantly reduces the size of my backyard, and with it, any usable space to construct a swimming pool. Additionally, the topography of the yard is such that there is significant slope on all sides, making construction within the existing 25-foot setback exceedingly difficult. Lastly, there's a utility pole from Dominion Energy in the backyard or on my property that, as a side note, I cannot find a recorded easement for that further limits the amount of usable space on the property. With respect to the second condition, the conditions I just referenced are not common to other properties in the vicinity, as my property is more severe slope than any other property along St. Hubert Way that faces Bear Swamp Road, nor is there any other property that has a utility pole on the property itself that reduces the amount of usable space of the property. Finally, every other home in the vicinity is situated towards the front of the property, leaving ample space in the backyard such that attempting to build in the existing 25-foot setback would be of little to no use. With respect to the third criterion, strict application of the ordinance in this case would unreasonably restrict the utilization of the property because the stated intent of the setback in the plan use development is to promote consistency, privacy, and neighborhood character, none of which would be undermined by the construction of a pool within the footprint proposed in the current site plan, as many properties within the Hun Club subdivision already have in-ground swimming pools, so there would be nothing that would undermine the consistency or character of the neighborhood. This is only further exemplified by the fact that both pool plans, the prior one that was deferred and the current one that is now before you, went before the Hunt Club HOA and were approved almost instantly. With respect to the fourth criterion, the authorization of the requested variance will not be of substantial detriment to the adjacent property or the public good, nor will the character of the zoning district be harmed as my only neighbor, technically my only neighbor, period, the other adjacent properties owned by the HOA, so it's just common space, expressed their concern in response to the original plan submitted for review at the April meeting, and has since approved the modified plan. The plan before you is a byproduct of, some would say, even painstaking negotiation and compromise between myself and my neighbor, but ultimately we were able to come to an agreement. And it was created to assuage her concerns. And the only other adjacent property owner, as I mentioned, is of course the HOA. And as mentioned, they have already approved the plan. And then lastly, the character of the zoning district will no way be harmed as the requested variance is extremely modest. It's only 4 feet. And there are many other properties within the Hunt Club subdivision that have in-ground swimming pools. With respect to the 5th and 6th criteria, the variance does not involve an unpermitted use, nor does it change the zoning district boundaries. Additionally, the need for the variance is not a result of my own actions as the property owner, because while, of course, it is my choice to install a swimming pool, I play no role in the configuration of the lot, the topography of the lot, the choice to situate the house so far back on the property as opposed to more towards the front of the property, or the decision to allow Dominion Energy to place a utility pole on the property without a recorded easement. Again, it may be recorded, I still haven't found it. And then lastly, with respect to the 7th criteria or criterion, the granting of a variance does not substantially conflict with the comprehensive plan or the purpose of the ordinance, as the respective variance is relatively minor in scope. Again, it's 4 feet, and is in line with other variances that have previously been granted within the Hunt Club subdivision. As has already been noted, probably ad nauseum at this point, nothing about the construction of an in-ground swimming pool in my backyard will disrupt the character of the neighborhood. Rather, it is likely to enhance it, given just the overall nature of the neighborhood and the fact that there are already several homes that have in-ground swimming pools. As it relates to privacy, we've already taken certain steps, including the installation of a 6-foot privacy fence with pool code gate locks, have placed security cameras around the property, and have planted privacy plantings along the relevant property lines, including 7 mature Savannah hollies along the property line that faces St. Hubert Way, and 10 mature Alphonse Carr clumping bamboo plants along the property line that faces Bear Swamp Road. I welcome any and all questions.
Thank you so very much. Let me see if I'll start on my left if anybody has a question. No one on my left?
Well, first of all, I commend you for the thoroughness of your presentation and for sticking to the criteria. That's very much appreciated and doesn't always happen when people come before this board. My question for you is just related to the layout of the pool itself. And, just noting the grade change in your backyard and the request for 21 feet, it looks like you only have an apron of 1 or 2 feet around the edge of the pool. Is that going to be sufficient for installation of the pool with whatever fill material you got to bring in to install the pool?
I'm not an engineer, nor am I the builder of the pool, but my understanding is yes.
Okay.
Yeah.
All right. Well, with that, I'd appreciate you making changes and accommodating some of the requests that were made the last time you came before this board.
Any questions? Okay, we got one. Go ahead, Mr. Neal.
Thank you, Mr. Chair. 2 simple ones, I think. The pool itself, and I know nothing about pools, so this might be a dumb question. Is the pool a mold, or does it come in that configuration, and you're trying to fit that configuration in? The reason why I'm asking, Ms. Working, can you pull up the backyard map that has the overlay of the pool on it? Yes, that's exactly the sheet I'm looking at. So what I'm looking at is, it looks like 4 feet is what this is all about, going from 25 to 21. So right here, that little bubble is what's causing the problem, it looks like. And if the standard pool is that mold, okay, then that 4 feet is a problem. And that's why the variance seems reasonably. But if that bubble went straight across instead of just kind of going up like a bar graph, and that went straight across, that might be down to 1 foot. I'm just asking, I don't know how they build pools.
Sure. So this is not a prefab pool. It was custom designed. It's going to be gunite. I guess technically speaking, to answer your question, yeah, it could be designed to be within the 25-foot set. To a certain extent, it could be designed to be within the 25-foot setback. We tried multiple configurations, myself and the pool builder, just to try to find something.
You've answered my question.
Yeah.
I'm fine with it. And
Okay.
I echo my comments from my fellow commissioner that your presentation is very good. You've stuck to the criteria that we're looking for, and you've made efforts with your neighbors. So congrats on that, and thank you for that. Really, the only other question is the concern that the neighbor has. She's got a comment here about drainage, and she's obviously very concerned about her drainage. Now, I heard in your testimony that you've worked out a deal. Does that mean that she's withdrawing her negative comment here, or what? Tell me a little bit more.
That's correct. That was from April, as I'll note. And I submitted, well, first of all, before I submitted this plan for review before the board, I submitted it to her first. And so I submitted the email exchange between myself and my neighbor, and I asked in very explicit detail whether she approved this plan as proposed, and she put it before her father, who's a civil engineer, and she said she had no issues with it. So I would not be here if it were not for her being in agreement with the plan.
That's all I need, Mr. Chair. Thank you.
All right, anyone else on this side? No? Thank you so very much for your testimony. Do we have anyone else to speak in favor of this application? Do we have anyone to speak in favor of this application? Do we have anyone to speak in opposition? Anyone to speak in opposition? Very good. Case is closed to the public. Board members, do we have any general discussion? Any questions of staff? None? Okay. Therefore, I need a motion to approve or deny this particular case, ending in 955. Please. Yes, sir.
Mr. Chairman, in the case of BZA 0326000955, thank you. I make a motion that we approve this request for a variance. I think Mr. Marcus has already articulated the reasons why this meets the criteria, but I will go through it at the risk of being redundant. The first criteria are extraordinary exceptional conditions pertaining. We've heard testimony that the usable space in the rear of the house was caused by the developer's placement of the house, that there is a power pole that restricts placement of pools, and that it is a corner lot that also which restricts use of the property and placement of the pool. The conditions do not apply to the other properties in the vicinity because, again, of the configuration of the lot as a corner lot and the placement of the house as opposed to those in the neighborhood which are placed closer to the street and enlarge their backyard. That it unnecessarily prohibits, restricts use of the property. I think Mr. Marcus testified that many properties in the area have swimming pools, and this would unnecessarily restrict his ability to have a similar pool on his property. The variance will not be a substantial detriment to the adjacent properties. We heard that Mr. Marcus has worked with his neighbor with regard to her concerns and found a satisfactory answer that meets his desire for a pool and her need for concerns about water runoff. Will not establish a use not permitted in the zoning district. It will not. And the variance is not the result of the applicant's actions. As we heard testimony, it is because of the placement of the house, of the developer, the utility pole, and the shape of the lot. And finally, it will not establish a conflict with, it will not substantially conflict with the comprehensive plan.
Staff comments.
Oh, I'm sorry, this motion includes the staff requested compliance with the staff recommendations. Thank you.
All right, do we have a second? Second. Okay, I got a second. I saw one, Mr. Nelson. All right, any general discussion on that motion? All those in favor, please indicate by saying aye and raising your right hand. Aye. Aye. Any opposed? No. It's unanimous. So congratulations, sir. Your application has been approved. Within the next 10 days, you'll be getting information from our staff, letting you know the next steps in the process. Thank you so very much for coming twice and getting it done. Thank you. They may need it. Okay, so our next case tonight is case BZA 1025-00915. Ms. Working will be presenting that case for us.
Okay. The applicant, Brian Heatherly of HH Action LLC, is requesting a variance to allow the removal of a 40-inch DBH diameter at breast height Grand Sand Live Oak located within the Richardson Road public right-of-way to provide access to TMS number 33012000068 and 33012000069, including proposed lots B5A and B5B and existing lot B6. The applicant is represented by Neil D. Thompson, Esquire of Ford Wallace Thompson, LLC. Richardson Road is a county non-standard road with a 20-foot wide right-of-way access from Soligree Road on James Island. The existing 8-foot wide dirt travelway terminates at the northern boundary of TMS number 33012000066. The Grand Tree is located just beyond this point within the right-of-way near 33012000067. The staff arborist evaluated the tree and classified it as a grade B specimen in accordance with the Charleston County Zoning and Land Development Regulations Ordinance. Removal of a grade B grand tree requires approval of a variance by the Board of Zoning Appeals. This case was originally scheduled for review by the board on December 1st, 2025. The case was then rescheduled for February 2nd, 2026 meeting, at which time the applicant requested and the board granted a deferral. The case was next scheduled at the April 6, 2026 BZA meeting. At that meeting, the applicant requested a deferral to the next available agenda because they had hired legal counsel who was not available on April 6. The board granted that deferral. This is the location map or zoning map as well, showing the location of the tree. Location map. The zoning ordinance requirement, section 925B. 300-foot radius, aerials. And we posted the property on June 26, 2026 for this meeting. Solidarity Road, Richardson Road, and then the proposed plat and the approved and recorded plat. Regarding the approval criteria, we stated that it may meet 1, 2, and 3. It meets 5, and it may not meet 4, 6, and 7. The board may approve approval conditions or deny the request based on the BZA's findings of fact unless additional information is deemed necessary to make an informed decision. In the event the board decides to approve this application, we have some suggested conditions. 1, the applicant shall mitigate the removal of the 40-inch DBH tree by one of the following methods. A, submitting a mitigation plan for review and approval indicating the installation of canopy trees no smaller than 2.5 inches in caliper, equaling inch per inch replacement. B, depositing funds into the Charleston County Tree Fund as described in section 926 of ZELDAR. Or C, a combination of both A and B. Mitigation shall be completed prior to tree removal. 2, tree barricades constructed of chain link fencing shall be installed around all protected trees within 40 feet of disturbance prior to any construction pursuant to section 924 of ZELDAR. And 3, the applicant shall retain a certified arborist to monitor and treat all grand trees within 40 feet of disturbance throughout construction. A copy of the tree preservation plan shall be submitted to zoning staff for review and approval prior to zoning permit issuance. And to date, this is including all the meetings. We have received 11 public comments in support, 524 in opposition, and there was a petition with 2,245 signatures in opposition. Questions?
You did say 524 in opposition?
Yes. Total, but that includes all the meetings.
Yeah.
Yes.
Yeah. Mr. Neal.
Yeah, I'm trying to pull up the public comments, and I don't know if it's overloaded or what.
Probably.
Yeah, I don't, we can't even see one of them. I can't see the positives or the negatives or anything, so I don't know if that's just my laptop or what, but I can't.
Do you have the case packet pulled up for this meeting?
Yeah, I might
okay.
do that. I might get
because
access.
The comments in support are all in that packet.
Right.
Yeah.
I can probably go through my email and pull that up. I was just trying to.
On the very end.
It's only the new comments that have been put,
Right.
I think, on the.
He's got it on his. I'm sure it's just my.
But all the previous comments are on the case.
Are on the case?
Yeah,
Mine won't pull it up.
it's a lot. It's a big document.
I don't want to hold up. Thank you.
Yep, no problem.
Do we have any other questions? Yes, sir.
I had one, maybe it's more in the nature of a comment, but I thought at the time we heard this originally, and this is not dispositive of what I think how this should be resolved, but I agreed with our attorney in his legal analysis regarding standing. It's just unfathomable to me that the county would say on a public right-of-way that the county would have, that they wouldn't be a party to an action like this. I think I know the answer, but if we gotten anything in writing so we could, from the county, so we could understand what their legal analysis would be, why they wouldn't be involved in something like this?
No, we don't have anything in writing for that.
I couldn't.
No, there's nothing in writing from legal.
They didn't what?
They did not put that in writing, but that's what our legal department said. That
Okay.
they do have standing to ask for the variance.
Mr. Brown?
Say whatever you just said one more time.
They do have standing to request this variance. The applicant does.
Even though they don't own the property.
Correct. Yes. That was determined.
So is the county removing it? Or are they going to be?
They would remove it. They would remove it if you approve this request.
Any questions over here? Yes, sir, Mr. Nelson.
Thank you, Mr. Chair. Ms. Working, for this particular application, I know it's the subdivision process that's triggering this variance request. But if the owner of the property were to elect not to subdivide the property and just build one residence on that property, would a variance still be required to meet the fire code and
Yes.
actually construct a property or construct a house on the property? I think that's the only question I have right now. Thank you.
Other questions on this side? Okay, you got another question,
I
Mr.
do have
Brown?
Another one, I'm sorry. And maybe I misread it, but the access road beyond the tree gets taken down, there's going to be a road. Does that meet? It's going to be maintained by the owner, so it's private property?
No,
or is it county?
it's a non-standard county road. So it's a county road that's not going to be improved by the county. Did I explain that right?
Once you remove this tree and that road is non-standard, it's okay.
It just has to
approved
have
by
the
the
legal
county.
access for them to get access to these lots. There's 2 existing lots, and they're asking to create one more
And they'll
additional.
have the proper fire access to the, everything back there. Okay.
All good questions. Any more? There you go. All right, without further ado, please come on down. Let's see if this price is right. The applicant, if you please would, state your name and address for the record, and please tell us why we should approve this application.
Good afternoon, Mr. Chairman and Board. My name is Neil Thompson. I'm attorney representing the applicants, Brian Heatherly, who's here as well. Wanted to give you all an update as far as what is before the board in light of, you heard about the significant opposition to the removal of a tree. And since my involvement on behalf of my clients, our goal has been to seek alternative solutions to obtaining emergency access to my clients' lots that would involve not removing the grand oak tree. And so we've worked diligently and proactively in seeking alternative solutions. And I'm pleased to report that we've worked with the James Island Fire Department, and they have issued a variance. There's a letter to this effect, which I've got a copy of. I can provide to the board for your review and consideration. But the James Island PSD Fire Department issued a variance. This was on July 10th, just a couple weeks ago, issued a variance on the width of clearance to allow for passage around an existing grand oak situated along the right-of-way. In other words, we've got a solution that would save the oak tree. And what we're talking about now is the fire department is issued a variance that allows for emergency access for emergency vehicles to access my client's lots, and thus to have legal access in order for them to develop what has already been zoned a residential use parcel. And I'm happy to present a copy of this confirmation from James Island Fire Department.
Start at the very end, yes, please.
And so this would render the current variance request under 9.2.5 about a tree removal. That would result in that particular variance being moot and not necessary for review. And instead, what we would ask the board to review would be if a variance were to be needed, it would be for tree protection under 9.2.4, which I realize is not yet before the board, but I'm happy to report my client's compliance there. We procured at our own expense an arborist who has instituted a tree protection plan. That's Mr. Ari Fun, has a tree protection, and he's got a letter to that effect, which goes through criteria stating that the tree could be healthy, would remain healthy. There's sufficient a tree protection plan that would provide enough room for all traffic to maintain at least a 3-foot distance from the trunk of the tree. And when we look at it, and right now I'm just asking the board whether you'd like me to proceed with a 9.2.4 tree protection analysis, or if you deem that to be premature. So I just want to make it clear that what we're coming here today to say that a tree removal is no longer necessary, that we've got the variance needed from the fire department that they've made, and they have authority to do so, and that we're now at a stage where we're seeking simply a variance request for tree protection for the critical root zone of the tree, which we deem we've met by the measurements instituted by our arborist. I would also defer to county's arborist, Kyle Foster, who may have been out there as well. He may speak on this at some point, if that's something we want to evaluate today, as far as sufficient tree protection, which would meet the criteria needed for passage there under 9.2.4.
All right. That sounds like some good food to chew on. Since that's the end of your time, pretty much, because you're asking for encroachment. And what I want to do, I want to see if any of the board members has a question, and then we're going to refer to our arborist and see what his thoughts are with this as well. So with that being said, I'm going to start over here on my left and see if they have anything, because I know my right is ready. So, Mr. Jordan, you want to start off?
Thank you for this good news, because I was just sitting there thinking another meeting, another Grand Oak has to go. But anyway, I hope you do have good news. My question is, all these people in opposition, have you reached out to them before this meeting to give them the good news and get their input?
No, I'm sorry. That
I'm
has
sorry.
to come
Yes,
from him.
yeah. No, we have not notified those in opposition to the news of the fire department's variance and the pathway towards saving the tree. We have not notified them yet.
Okay. Well, it might have been a good move to get some of their feelings
Right.
in your favor.
Any more questions on my left?
They just received this on Friday,
On the 10th, yeah.
the 10th, and we received it today.
Go ahead, Mr. Nelson.
All right. Well, Mr. Thompson, thank you for this good news and for the Heatherleys for the work that they've done on this project. I know it's been probably a labor of love at this point, maybe not of love, but I think it is welcome news that the tree will not need to be removed. I don't know if we're going to have enough information to vote on whatever the encroachment might be, because at this point, not knowing if it's if it's 50% or 40%. That would be what we would need to see next in order to make a decision on this action. I'm certain that staff would be very happy to expedite the next hearing, is whatever that might be. I'll defer to Ms. Working on that one. But you removed a lot of the questions that I had for you coming up here. So thank you for taking the time to do that and keep working on this project.
Thank you.
Yes, sir. You.
Thank you for an excellent presentation and for a reasonable approach to saving the tree. So I can't imagine that the community would have any heartbreak with you saving the tree rather than taking the tree down. If I understand what you're saying today, to the degree an amendment to your variance request is made, you're seeking, I'm going to use a legal term you would use, nunc pro tunc. You made it originally, but you would have your application conform to the information you just got from the from the fire department. You really, given that you just got this on Friday, you haven't had an opportunity to communicate that to the community in a reasonable fashion. Is that what I'm hearing?
That's correct. Exactly.
And the only concern my colleague to my immediate, or the second from the left, would be is whether you're going to be able today to tell us what your plan is to make sure that the tree is going to be saved. Is that correct?
That's correct.
And can you do that today?
But yes, as far as the combination of the variance issued by the fire department, allowing for, and then our understanding from our own tree mitigation, tree preservation plan by our own arborist, and that of the county arborist, the measurements are there where the encroachment, we feel like there is room for emergency access.
Okay, so to respond to my colleague's question, I guess we have two arborists here who are going to be able to help us before a decision needs to be made to defer or to hear this today.
Well, I know the county's arborist is here and can speak on that. As far as the arborist my clients have retained, today we just have his letter referencing his tree preservation plan.
All right.
But if we need to come back with him for testimony, we certainly we defer to the board there.
I don't know whether that's necessary.
Yeah.
I think we have Mr. Foster is a very well qualified arborist, but I just want to understand before. I didn't want us to make a premature decision to defer when we could decide today.
No, I would think what Mr. Foster, I would defer to his findings to date.
All right.
What we would prefer would be for you all to make a decision on this application today, vote it up and down, or for them to withdraw the application, because to us it's a new section. You have not seen the plans. There's 3 documents that we received today that we want y'all to see. We'd have a new staff report, and we could get them on the September 14th agenda with a new case number.
I agree.
So
I think
this case, but they can't have 2 active variances, so they have to decide, y'all have to decide if you want to just vote this up or down, or have them withdraw this application, and we can get them, like you said, we can get them in soon, as long as they apply by July 24th for the September 14th meeting.
I would think we would have enough information to decide, but that remains to be seen.
So are you?
Staff is, I'm sorry, go ahead.
No, go ahead.
Go.
There's an easy solution here.
So, no, thank you. Sir, do you understand the crux of the matter and what we're trying to do here tonight? What you're asking for, but what we have to do legally?
Yes, to my understanding, what we need, there can't be 2 different variance requests pending. So to the extent that the tree removal variance request needs to be amended to a tree protection variance request under 9.2.4.
No, it can't be amended. Either
We've
you
advertised
ask
for the grand tree removal.
Either you ask for a vote on the current application, or you can withdraw that application and bring the new application.
So what I'm also giving you an opportunity to do is to refer to your client quickly. I'll give you 1 moment to do that, 1 minute to do that. Hopefully that'll be sufficient.
Yeah, My comment I was going to make while they're throwing was, this is an easy decision. They should withdraw, or we should just vote on what he's asking us not to do, the tree removal. So we should just vote it down or let him withdraw it, and then he puts in a new application for what the variance that he needs, and then we move on. And if staff can expedite it, but it gives us all the information, and we move on. It's very
Correct.
easy.
I'm just giving him an opportunity to do it.
Yep.
That's all.
Mr. Neal, that's exactly correct. We would today withdraw and ask that the new variance request be expedited as soon as possible.
Okay. So, board members, we have a request to withdraw this current application, and for them to. No, ma'am, you cannot. What? No, ma'am. This is not up for this. Do you want me to call security?
No, sir.
Okay. Well, if you would please have a seat. If you would please have a seat.
We've been out there 4 times.
So at this time, I need to have a motion to approve or the withdraw or reject, deny the result, withdraw. Do I have anyone to make a motion?
I make a motion that we approve the request by Mr. Thompson to withdraw and have expedited a resolution of the case.
Do I have a second?
Second.
So I have a motion that's been properly moved and second. Any discussion? You have a discussion, Mr. Jordan? Your question?
Question.
Yes, sir. Your question being?
Is it improper to have this motion on the floor to have public comment?
No, not at this time.
It's not improper.
No, it is, it will be, there won't be anything on the floor.
There's nothing on the floor. So this is just up for us. On this floor, not that floor.
But it's the same tree.
We can make comment to the public after the motion is done. It's very easy.
What good is the comment if you already made a vote?
I would request.
Oh, you are, ma'am,
Motion to withdraw, sir.
say again.
I would request being able to speak to the motion to withdraw, which is on the floor. With your indulgence, sir.
Just let her.
I represent 2,400 signatures and over 500 comments. My name is Susan Milliken, and I am here to represent the Save James Island group today. I would request to speak on the motion to withdraw, sir.
You're gonna vote?
Yeah.
Are you ready to vote?
Is this board ready to vote?
Yes.
Okay. So, at this time, all those in favor indicate by saying aye. Aye. Any opposed? Carries. So it has been. So I will give you that opportunity to speak, though. So your request has been approved to withdraw. Yes, ma'am. At this time, I'll give you an opportunity to speak.
Thank you, sir.
Please state your name and address for the record, please.
My name is Susan Milliken. I live at 762 Fort Sumter Drive. Thank you for the board's indulgence. We have been out here.
So let me stop you one quick second. I apologize if I was a little stern, but we
That's
have to
okay.
follow protocol.
okay.
But I appreciate your effort to come forward and to speak for that grand number of people, okay?
I understand.
So I'll give you 2 minutes, okay?
Thank you, sir.
Thank you.
As you know, your board is a quasi-legal body. The rules of procedure are super, super important. I don't know if you have county legal counsel here in the room today, but it's very important how matters proceed with this body. So what we have before us today is a variance request that we all prepared for, that we gave public comment for, that we signed in to speak on. Mr. Thompson, I believe his name is, was able to make a 5-minute statement for his client pertaining to the variance request. So I would ask, starting now, that I be able to make a 2-minute comment. I'm not able to make a 5-minute comment in response to what is on your agenda today, which is a legal proceeding or a quasi-legal proceeding. We are very mindful that appeals could be coming in the future on this matter or on other matters, and that litigation could happen, so we would just like to have a chance to speak. Okay, again, my name is Susan Milliken. I'm representing Save James Island. We started a petition in March of this year that now has over 2,300 signatures. The outcry on this one tree has been astronomical. We've never seen anything like it. We started our group in 2011. We are about preserving trees, green space, culture, and history on James Island. This tree is special. It's healthy. It's over 200 years old. And we are absolutely grateful and thrilled to hear of this plan that the applicant has put before you. But we would ask that they do come back with the encroachment variance and go through the legal process, not combine anything. I appreciate the way y'all took this up just now with the motion to withdraw, but of course, to follow the county's ordinances, they would need to come back with the encroachment. As far as I'm concerned, I can only speak for myself, I would have no problem with an encroachment. Because the tree is located on the county right-of-way, I would ask that the county staff please consider protecting it now with a fence, with some kind of a protective fence. This has become so controversial. We've had people come in from North Carolina. We've had the slave dwelling project. We've had the witness tree project. We're overwhelmed by this, sir. So if it is on county right-of-way, if it could just have some orange fencing around it while this matter continues through the process. But I appreciate the applicant being able to come back for an encroachment, and I personally would have no problem with that. I trust their arborist. He is highly respected and very excellent, and he is the one who said this tree is over 200 years old and in good health, and the county arborist agreed. But this tree has touched a nerve in the community that we've never seen before.
Okay.
So thank you.
Thank you for your time and your testimony. Okay. Now,
It's over.
it's over. It's over.
Next
So
applicant.
the next case that we have, if I can pull up. Okay, here we go. Our next case that we have will be done by Mr. Carlisle. It's case BZA 10-25, 26-00976. Mr. Carlisle.
And thank you. Good evening, board members. The applicant and property owner, Kyle Norton, is requesting a special exception to establish a short-term rental property, extended home rental, EHR, at 524 Carpenter Street, TMS number 343-1400038 on James Island in Charleston County. The subject property and adjacent parcels to the north, south, and west are located within the low-density residential R4 zoning district, while the adjacent parcel to the east is located in the urban residential UR zoning district. According to Charleston County records, the property contains a single-family residence constructed in 1966. The applicant proposes to operate the residence as an extended home rental by offering 4 bedrooms for short-term rental use, accommodating a maximum of 10 occupants, and providing 6 on-site parking spaces in compliance with the Charleston County zoning ordinance. The property owner has indicated they will manage the rental operations. This location of the property when looking at the county as a whole. This is the zoning ordinance section pertaining to short-term rentals in the R4 zoning district. It's a 300-foot radius map, aerials of the property. We posted the property on June 26th. Pictures of the subject property and parking. Pictures of adjacent properties. Carpenter Street, the site plan showing the parking. And this is the tenant notice, the recorded plat. Regarding the 3 approval criteria, staff stated that it may meet criteria 1 through 3, and we received 10 public comments in opposition to this request. The board may approve with conditions, or deny a case based on the BZA's findings of fact, unless additional information is deemed necessary to make an informed decision. In the event the board decides to approve the application, it should consider the following conditions recommended by staff. 1, prior to the zoning permit approval, the applicant shall complete the STRP, limited site plan review process. 2, the use shall comply with all requirements of Article 6.8. 3, this property shall not be used as a short-term rental for more than 144 days in aggregate during the calendar year. 4, the property owner shall be responsible for ensuring that tenants comply with the Charleston County noise ordinance. And 5, the maximum occupancy for the short-term rental property use shall not exceed 10 occupants at any time. Any questions on the?
Do we have any questions? Very good. Thank you so very much, sir.
Yes, sir.
Is the applicant present? Thank you. Please come forward. Please state your name and address for the record, and please tell us why we should approve your application, sir.
Good afternoon. Thanks for the time. My name is Kyle Norton of 524 Carpenter Street. And just a little background, I purchased the home actually during a kind of difficult time in my life and was living there as a primary residence. And since then, things have luckily settled down a little bit. And instead of selling the home, I was hoping to, rent it out and find another avenue as opposed to just selling it. So I grew up in the Low Country. I'm born and raised here in Charleston. I've got deep roots in the community. I know some of the neighbors. I know there's some pushback as well, but I do know some of the folks in the area. I believe my application satisfies the criteria under Article 6.8. The property is zoned R4. It meets the parking requirements as the site plan shows, with all the spaces needed on the gravel as well as in the grass next to that gravel driveway area. I'm also prepared to comply with all operating standards and conditions the board may impose. I am a licensed real estate professional. I do have a background with some property management. I am fully committed to operating this in a way that adheres to not only the rules but also the community as well, and protects the noise ordinances and anyone else that might have problems. I'll be available anytime to help out. I'll be managing myself. Again, I'm just a kind of average guy. I'm not an institutional investor or anything like that. I do have a neighbor, as I mentioned, who wasn't able to be here today, who actually does some of my landscaping, so I want to try to give back to the community as well. But I think that I'll be able to operate this, hopefully, again, in a way that doesn't intrude on the community and also complies with all of the criteria that you guys have set forth.
Very good. Let's see if anyone has a question. I know Mr. Truslow has a question for you, so we're going to start with him.
Yes, sir.
And we'll get Mr. Sedell next.
I always ask these questions because it's very important. Septic or sewer?
It is on sewer.
All right.
Yes, sir.
And I ask a lot of these questions because I live on the Isle of Palms and we have more problems.
That's where I grew up. My mom still lives in the house I grew up in out there.
And you can imagine, for when you've got short-term rentals, they come on a certain day, they leave on a certain day. We want to make sure that the trash will be put out the day before.
Yes, sir.
So that dogs don't knock it over, raccoons and coyotes and everything else. And then the trash cans are brought in rather than left on the street. What provision do you have for those issues?
I actually have someone who lives nearby who helps me out with things like that. So they've said they're happy to make sure that trash is taken out the night before and brought in. I also live downtown, so I'm close enough that I can hop over there and check on that as well.
So what is that the plan, to have somebody take it out the night on the day before?
Yes, sir.
Trash is to be picked up and to take it back in that day?
Correct.
All right. The next thing is I noticed that I think 4 of the parking spaces are in the grass, or not in the, I don't know that that's necessarily a problem, but what we see a lot of is it looks like in somebody's front yard, it looks like a used car lot.
Right. Yes, sir.
How are you going to deal with this?
Well, I'd be happy to add more gravel if needed, or add any kind of landscaping that might avoid it optically not looking so nice. But the ones on the left there before the other on the far side of the parking visual that you have there, those are on the grass that lead up to a gated fenced area. That it really does kind of look like another driveway. That would be an easy one to add gravel if that would help.
The problem that I see, and you've done an excellent job, and it's all to scale, that the cars at the top, the 3 people don't always park like that. They
Yes,
just
sir.
park all the way across the front, the front yard.
Right.
So again, it looks like a used car lot.
Yeah.
What are you going to do to make sure that they don't?
I'll provide, specific instructions to the guests. Again, if there's any feedback from the neighbors that it looks like folks aren't parking appropriately, I'd be happy to address it in real time. But my best, I think, opportunity is just to have it in the introduction message or whatever you have with the guests to say, this is how the parking works. I could provide that as well to make sure that they know. I'm not sure that there will be that many cars there at any given time, but it is possible.
Okay. And one last question. Have you reached out to your neighbors on either side and across the street to see whether you've been able to satisfy their concerns?
I have not yet. I honestly, I wasn't really prepared for. I didn't know quite how detailed this process was going to be, and I just received the notice from you guys on Friday afternoon about the public feedback. So I haven't had a chance to talk to the neighbors yet.
All right. And then one final thing, and then I'll be
Yes,
done.
sir.
You got 4 people in one bedroom, and I don't mean this at all in an insulting way, but you give in prisons they get more space than 4
Sure.
people in a 10 by 10 cell. Does that cause any concern, or should it cause us any concern?
I don't see any concern with it. I think it's more of a, kind of up to the guests if they want to, have 2 people sharing a bed. One of the bedrooms does have bunk beds.
That's what I was going
so
to say. It's got bunk beds.
It just has a bunk bed, yes, sir. So my guess is that folks can choose to bunk, side by side in the bed or not. But it's, it's very comfortable in the room. It's a bunk room, and then the other ones are, individual rooms with queen
So
and
it's
king
got
size
4
beds.
beds in the 10 by 10 room?
It's just the 2 beds in the one room, the bunk bed, and then the other rooms just have 1 bed in them each.
Thank you.
Mr. Brown? No, I promised Mr. Sedell. Mr. Sedell first.
Thank you. Mr. Chairman. Mr. Norton, thank you for your testimony.
Yes, sir.
You said that you hadn't spoken to your neighbors yet.
Not yet, no,
about
sir.
this. Would you be willing to provide you're going to manage this property yourself,
Yes,
you
sir.
said. Would you be willing to give your personal number to all the neighbors around?
Absolutely,
this
I'd be
for
happy
them
to.
to contact you if there's noise problem or some parking problem or something like that?
Absolutely, yeah. I'd be happy to, and I would. I plan to be proactive, so I'd be happy to provide my number and have face-to-face interactions, whatever I need to do to help folks feel comfortable. Or again, anytime I'm needed. I live downtown. I'm less than 15 minutes away, so I'm always on my phone. I can be available at any time.
Okay, that was one of my questions. How long would it take you to get to the residence?
Yeah.
There's an issue. 15 minutes, is that what
That's
you
the
just said?
maximum. Yeah, that would be if there was some traffic on.
And if you're not available, everybody takes trips or
Sure.
goes away, who would be taking that for you in your absence?
My brother lives here locally as well. He's in the he and I have worked together on projects before. He's in construction. He's very hands-on. He said he'd be happy to watch out for me if I'm out of town and not able to respond right away.
Thank you.
Mr. Brown?
My one question, I noticed there's quite a number of comments
Yes.
against this. Do you have any of your neighbors that are in support?
Yeah, I do. I do have one. He wasn't able to make it today. Like I said, he's another gentleman who I grew up with here in Charleston. He lives just down the road a few blocks. He's renovating his house right now. He just had another child, but he actually does landscaping. He does landscaping for several people in the community as well. He takes care of my property also. So, like I said, unfortunately, he wasn't able to be here today, but he's well known in the community. He knows me as my character and as the potential operator of this, that I'd be able to to take care of it. But I do understand the concerns. I know there's some other homes in the general vicinity that have this extended rental permit, but every neighborhood is different. I understand the folks' concern, and like I said, I'm available. I'm here. I'm happy to help in any way I can.
Did you say he's a number of blocks away or somewhere else around?
Yeah, he's just
in the
up.
neighborhood?
He's up towards the. Sorry, a little bit nervous, blanking on the road. The road there. He's in the neighborhood a couple of blocks north, towards the main road there.
I guess you can just sort of see a concern we might have that there's nobody in that general area that's
Sure,
in support, where it usually helps to.
Yeah, I wish you
You know,
could have
you've had conversations with the neighbors; they understand, but all we've seen is the.
Yeah, I wish I would have
opposition.
had time to talk to him again. This wasn't fully planned out. Again, my life was kind of in a difficult place, and luckily came out on the other side of it, but wasn't quite as prepared to again maybe have the pushback and go through all of this. But
All right, thank you.
Mr. Neal?
Thank you, Mr. Chair. One comment, and then I want you to comment on a question. I suggest if you're going to manage it yourself, if you're going to self-manage and not have a company, that you put some type of signage out so that neighbors or whoever can be aware of who to contact if they want to complain or have whatever.
Sure.
So with a phone number, email, something like that,
think
that's
that's a good
helpful.
idea.
We
Yes,
can't
sir.
require it, but it's just something that will help the ease and the problems. Second thing, I don't see anything about, I do have some concerns about the number of occupants. That being said, the reason I'm asking these questions is because of this. What are you doing for monitoring of noise so that we don't impede in the neighborhood or the other homes around them? And also, vehicles are you, not vehicles as in cars, but websites or whatever are you using to screen applications? I mean, are you trying to get wedding parties in there? Are you trying to get a family with just one kid? I mean, that type of discretion is important. Why don't you tell us what your plans are for that?
yes, sir. I'll be hosting on Airbnb. They do have systems in place where you have to. Someone can't just book it. For example, on the day of, if it's vacant, someone can't book it and throw a party because they're trying to find something that's open last minute. They have systems in place where you can have a way to vet them. In my experience, in properties like this, it's a lot of families. There are the occasional guys trips or girls trips, but I don't foresee it being a problem that it's going to be folks trying to. It certainly wouldn't be advertised for events by any means. I will be installing noise monitors,
There you
and
go.
then I've got security cameras on the exterior as well to monitor things. And I can also, when it comes to the parking, this is the parking that's required for the home, for the city. But I also don't have to provide this many parking spaces to the guests. I could say no more than 3 cars allowed.
Right, that might be something to help you. Just as a follow-up, staff will probably correct me if I'm wrong, but I think this permit's for a year. If it was to get approved, and if you've got this many people that are in opposition to you, they're going to be monitoring you.
Of course.
And if they come back and a lot of noise complaints and all these issues that they said, hey, I told you it was going to be a problem, well, then your renewal and stuff like that, you're going to have problems. So
Right.
vetting that on the front end will help you if this is something that, hey, if there isn't a problem, you hadn't had any noise violations, or hadn't had any city come out to check on it, then it's an easy deal.
Yes, sir.
I'm fine, Mr. Chair. Thank you.
Okay, let me see if I got any questions on my left. Yes, sir.
One last question.
Yes, sir.
So I'm trying to figure out how to fit 10 people in the house. How many square feet is your house?
It's right around 2,000 square feet. So there's 4 bedrooms. In theory, to fit the folks, you've got 2 people sharing each bed essentially, and so you've got a king bed in the primary bedroom that sleeps 2, a queen bed that sleeps 2. Let's say they're all couples or whoever wants to bunk, and then the 2 queen beds in the other room that could each sleep 2. If folks want to, sleep on a couch or something like that, I suppose they could as well.
And then 2 single beds in the
Queen beds in all queen beds in all 3 bedrooms, or I'm sorry, a king in the primary, 2 queen beds in the other 2 rooms, and 2 queens, one over top of each other in the bunk bedroom. And then several couches, just kind of in living spaces.
Thank you.
All right. Thank you so very much for your testimony.
Thanks for your time.
Do we have anyone to speak in support of this application? Do we have anyone to speak in support? Do we have anyone to speak in opposition? Yes, sir. Please come forward to the podium. Please state your name and address for the record and why we should disapprove. You may want to pull that mic down just a little bit. Thank you, sir.
Good evening. So my name is Jared McNeil, and I live at 527 Carpenter Street with my wife and 3 children. We live directly across from 524 Carpenter Street.
Thank you.
We've been residents of the neighborhood since 2014, and I'm here to respectfully ask the board to deny the request for a special exception to operate on extended home rental at 524 Carpenter Street. Carpenter Street is a small street of just 18 homes, and families have chosen to put down roots here because it's a low-density residential neighborhood where neighbors know one another and children play outside. And that character didn't happen by accident. It's the result of years of investment by the people who live here, all under the protections of the county's residential zoning. It's that established character the board is being asked to consider. I also want the board to know that many of my neighbors share these concerns, which you've already stated. The people who experience this neighborhood every day overwhelmingly believe this proposed use is not compatible with the residential character of our street. I appreciate the applicant's proposed conditions regarding parking and trash service and house rules, but those conditions don't change the question before the board. The issue isn't whether the property can be managed well, it's whether this use itself is compatible with this neighborhood. I also want to briefly address the surrounding neighborhood. Carpenter Street is a one-way street, and Woodland Shores Road is also a one-way street. A dead-end street, not one-way, sorry. Carpenter Street's a dead-end street, and Woodland Shores is a dead-end road. And they're used every day by residents walking, exercising, walking their dogs, children riding bicycles, but there are no sidewalks. So pedestrians and vehicles necessarily share the roadway. Woodland Shores Road has a single entrance and exit at Riverland, and that means every resident, visitor, delivery truck, school bus, and service vehicle enters and leaves the neighborhood using the same road. This proposal would create a continuing turnover of visitors unfamiliar with the neighborhood, increasing traffic on roads designed primarily to serve a small residential community where pedestrians and vehicles share the roadway. I believe that's an appropriate consideration when evaluating whether this use is compatible with the neighborhood. The ordinance asks the board to determine whether this use is compatible with the neighborhood and whether it will adversely affect the character of the immediate community. A special exception is appropriate only when these standards are met. Respectfully, I don't believe this application meets those standards. The ordinance doesn't ask whether this proposal can be managed. It asks whether it's compatible with the neighborhood and whether it preserves the character of the immediate community. I don't believe it does. And I'm asking the board to deny this special exception so Carpenter Street can remain what it was intended to be and what the residents have made it, a low-density residential neighborhood where people live. Thank you.
Thank you so very much. Let me see if anyone here has a question for you. Anyone on my left have a question? Mr. Jordan.
So has the applicant before today reached out to you to try to tell you his plans?
I've never met the applicant.
How close do you live to this place?
Is it right across the street?
Right across the street.
Right across the street?
Directly across the street, yeah.
Thank you.
Anyone else? Yes, sir, Mr. Neal.
Are you aware of any other short-term rental, extended short-term rental areas in your area? And do you have it? Because I believe we had staff testify that we have some in the area. But have you had any issues with any in there?
So we don't have any on our street besides, like there's a tiny home, but the lady lives there and it's on her property. There are no rentals where the owner doesn't live on the premises. Actually, in the entire community around Woodland Shores, I haven't seen any.
Okay. Thank you, Mr. Chair.
Anyone else? Yes, sir.
2 questions, a follow-up on the question that was just asked
Yes, sir.
by my colleague. Is it correct you're not aware of any homes in the area that have 10 residents at any one time?
So I don't know of any in the area. The owner doesn't live on the premises. I also don't know of any that allow 10 people at a time.
Okay. All right. Then the second one is related to cars. Is there anybody on your street or in the immediate vicinity that'll park, that's parking not only cars in the driveway, but have the access to park 4 cars on the front lawn? Does anybody do that? Is that customary?
Well, I can say so.
Where you live?
I have 3 adult children, and we all have vehicles, and we have 5. And it's very hard for us to get in and out of the driveway. We also do park on the grass beside the driveway. But when everyone's home from college, it's hard to fit 5 vehicles.
All right. Thank you.
Okay, are we good? Thank you so very much for your testimony.
Thank you.
Yes, sir. So at this time, sir, you have the right of rebuttal, limited to 2 minutes, if you want to respond to that. And you have to please state your name and address again for the record.
Yes, sir. Kyle Norton, 524 Carpenter Street.
Look this way, please. Just keep your eyes on me.
I just wanted to want to say sorry I haven't had a chance to meet everybody in the neighborhood. As I mentioned, I am familiar with their house because it's hard not to notice the cars that are parked along the street there. So I'd be happy to make sure that, again, we can put a cap on the number of cars. What the city says is allowed there is one thing. I can just say no more than 3 cars allowed that fit right into the spaces there. I do absolutely understand the concerns and the intention of the neighborhood. I myself have a 6.5-year-old daughter. She was with me. I'm sorry that my neighbors never saw me there in the several months that my daughter and I were living there during my separation from my wife. So I absolutely understand the concern. One of the reasons why I love the neighborhood was because of all the things he mentioned. And again, I'm happy to provide, be a point of contact and be someone that folks can reach out to and lean on if there's any issues. I really don't want it to be I didn't want this to be a big problem, and happy to do whatever I can to mitigate any potential issues.
Okay. So I know Mr. Neal has a question, but I might as well let him answer. So you made a statement that you're willing to limit the number of cars to 3?
Sure, yeah.
Though
I think that would be a reasonable number that fits.
You all can't grant a variance for parking for SDRs, so.
Say again?
He could say what he does, but that's not going to be a condition
Right.
of approval.
Absolutely.
Yeah, I just mean that within, within the, the parameters of the rental itself, I can folks can say, oh, we've got 8 people coming. How many cars are we allowed to bring? I can just say 3 cars is the maximum. That's a pretty easy one to enforce, I believe.
So that's not going to fly? You're shaking your head.
I mean, the requirement's the requirement.
Oh, the requirement's the requirement, but
yeah.
What he can limit, that's one.
Yeah, I just mean what I can limit to the guests themselves.
Mr. Jordan?
So how many residents would you estimate you've spoken to in the neighborhood about this?
Just the one, the friend of mine who lives down on Woodland Shores there.
One person?
Yes, sir.
Out of how many residents?
Several hundred, I would guess.
Well, it just seemed like to me the first one you would have spoke to was the one right across the street from you.
Perhaps, yes. Yeah, that's reasonable.
Okay, thank you.
I had one. Maybe it's in the nature of a comment rather than a question. But I have a problem with 10 people in a small house. I wouldn't have a problem with 8. But
Yeah.
Are you insistent on 10?
No, I think
versus-
if 8 is a number that people are more comfortable with, I'd be happy to accommodate that.
Would you modify your application to say that you're fine with the max number of people being 8?
Sure. Yes, sir.
Okay. Thank you.
Okay.
My question is for staff after we close. So.
Okay. Anyone else have a question for this applicant? Mr. Pratt? Okay. Thank you so very much for your testimony.
Thank you, sir.
All right, at this time, the case is closed to public board members. Do we have any question for staff? And you do. Start.
My only one was, do we have anything on record about any short-term rentals or extended home rentals in those neighborhoods?
So there's no short-term rentals on Carpenter Street itself. Within the larger kind of neighborhood that Woodland Shores runs down,
Right.
there was 4
So-
active short-term rentals.
So we had heard testimony that he wasn't aware of any of them, so he's not even aware that they're there. So it's hard to just say that the general comment that this is bad character for the neighborhood. So they're operating there without it. That's just my comment. I was making sure. How many homes are in that neighborhood?
Oh, I mean, it's got to be close to triple digits.
Yeah, okay, that's fine. Thank you, Mr. Chair.
Mr. Brown, you had a question?
Yeah, my question centers around our discussion about parking. What are the rules on if there's 8 people? And I know what he can say to whatever, but the rules are that we have to have, 4 parking spaces for 8
It's
people?
per bedroom, plus per the use, so the use of the house alone requires 2. 4 bedrooms, 1 per bedroom is 4, so 6.
So it's 6 no matter what?
Right.
Okay.
Now, whether he uses all 6, but we
Yeah.
can't grant a variance to have less than 6.
Yeah, that's what I was making sure of. We weren't overstepping.
Yeah.
Thanks.
Good. We good? Okay. Board members, do we have any other questions, any other general comment, general discussion? So at this time, I'd like to ask for a motion to approve or deny. Anyone?
Sure, I'll
Thank you, Mr. Brown.
Be happy to make a motion for BZA case 0526000976. My motion would be to approve this request, special exception. I feel like it meets all 3 criteria. Is it compatible with existing uses in the vicinity and will not adversely affect the general welfare or character of the immediate community? As we heard, there are several other homes and that he didn't even realize that they were short-term rentals there. So I feel like we've met that requirement. Adequate provision's been made for setbacks, buffering, fences, landscaping. I believe I heard there are fences and trash will be taken care of, and parking, noise monitoring and such. So that's taken care of. And criteria number 3, it complies with all applicable rules, regulations, laws, and standards of this ordinance. I believe we've met all of those. This would also, if there are any other requirements of staff on this? Do we have? Yeah, and just to verify, this is, my motion is with reducing the number, his request to reduce it to 8.
Okay. Do I have a second? All right. We have a motion that's been properly moved in a second. Any discussion? All right. All those in favor, please indicate by saying aye and raise your right hand.
Aye.
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 Those opposed? 1, 2, 2. Okay. It carries. Thank you. So your application, sir, has been approved. Within 10 days, you'll be getting information from staff letting you know the next steps in the process. Once again, congratulations and have a good night, please. Okay. Our next case tonight will be BZA 0, excuse me. What is our next one we have up now? 978. Yeah. BZA 0526000978, and Ms. Workin will be doing that one.
The applicant, Zach Carmel, on behalf of the property owners, Beth and Jay Lucas, is requesting a variance to modify required setbacks and buffers, the 50-foot critical line setback, the 35-foot critical line buffer, and the 15-foot interior side setback at 1445 Cat Island Parkway, which is TMS number 617-14-00074 in the east area of Charleston County. The specific variance requests are as follows. Reduce the 50-foot critical line setback by 15 feet to 35 feet for a portion of the proposed residence. Reduce the 35-foot critical line buffer by 5 feet to 30 feet for a proposed cantilever decks. reduce the 15-foot interior side setback by 5 feet to 10 feet for a portion of the proposed residence, and allow a pervious driveway and walkway within the 35-foot critical line buffer. The subject property contains 0.73 acres of highland. The subject property and adjacent properties are located within the rural residential RR zoning district in Phase 2 of the Paradise Island subdivision, which was platted in 2004. Charleston County adopted required setbacks and buffers from the critical line in 2001. The critical line location was established by the South Carolina Department of Environmental Sciences, SCDES, Bureau of Coastal Management, BCM, which was formerly the SCDHEC, OCRM. On March 2nd, 2026, the BZA denied the applicant's variance request. The final decision and order of that case is in your packet. The prior request sought approval for to reduce the 50-foot critical line setback by 24 feet to 26 feet, and to reduce the 35-foot critical line buffer by 9 feet to 26 feet. Let's see. The proposed request had been modified from the previously denied application. Sorry, I kind of messed up there. Anyways, so that was, they had scaled back their request from the previous request, and I think at that meeting we discussed shifting it more so that they would ask for the side variance. Oops, sorry. This is the location map and the 300-foot radius, aerials, the zoning ordinance requirements, posted the property on June 26th. Regarding the variance approval criteria, we stated that it may meet 1 through 4 and 6 and 7, and that meets 5. The board may approve approval conditions or deny the request based on staff's findings of fact, unless additional information is deemed necessary to make an informed decision. In the event the board decides to approve the application, the board should consider the following conditions. 1, silt fencing shall be installed along the critical line and at the 35-foot buffer, except for approved encroachment areas prior to commencing construction, and it shall be maintained for the duration of construction. 2, the applicant shall implement stormwater mitigation measures such as rain barrels and or rain gardens to reduce the flow of stormwater into the marsh. 3, encroachments shall be limited to the footprint areas shown on the submitted site plan. 4, the required 35-foot critical line buffer shall be maintained in accordance with Charleston County's ZELDAR section 4247, except for areas approved for the encroachment. And 5, the areas of driveway and walkway that encroach the 35-foot critical line buffer shall be pervious. Any questions?
Any questions for Ms. Working? Thank you, Ms. Working. Is the applicant available and present? Please come forward, state your name and address for the record, and please tell us why we should approve your application, sir.
Hello, my name is Zach Carmel. I live at 4650 Cape Island Drive in Allendale, South Carolina, 29429.
Good to see you again, sir.
You as well, sir. It's a difficult lot to build. Yeah, sorry. The lot's kind of a difficult build, and without changing the integrity of the subdivision and trying to keep the same look throughout, I'm requesting a variance for the 35-foot buffer in lieu of the 50. I've made adjustments to require, allow more buffer than what I was from before by taking your advice and requesting a 10-foot off the adjacent property line, which is my parents' home, and they don't have an issue with it. And that would be less impedance on the critical line as far as rain runoff. The impervious or pervious driveway being gravel, it'll help with runoff, and I'll be doing mitigation for as far as sweetgrass and stuff to prevent rainwater runoff and erosion, and just I'll not be jeopardizing the integrity of the neighborhood, because all the houses on that street and many in the neighborhood have had to have the same request for the 35-foot buffer from the critical line in lieu of the 50.
Okay. Finish?
Yes, sir.
Okay. Let's see if anyone up here has a question.
Oh, I'm sorry. I didn't mean to interrupt. I forgot. I did, to y'all's, what y'all wanted me to do, I brought this to the HOA, and they made a suggestion after I resubmitted it from the last time to slide it forward even further and also do the 10-foot. And I met with them out there, and we saw that that was doable, even without that power transformer even being in the way. It's doable, so we slid it forward, and I've submitted that to them, which is the same one that y'all have today that Ms. Working probably will be showing. So they would not give me a full approval because it takes a full submittal, which would require engineering and colors and textures, all the stuff that I was just trying to get something to show y'all that I'm working on the footprint.
Okay.
That's it.
Okay. Let's see if anyone has a question for you. Anyone on my left to start off with? Okay. Anyone on my right? Okay.
Thank you for coming again. I recall distinctly when you were here before, and concerns were expressed then, and especially by my colleague to the far right. My question for today, given what you've said, it's kind of like trust but verify, if you've ever heard that. What do you have for us to look at that you have from your HOA? Did you get any document
Yes,
from
sir.
them?
I have an email here.
So to cut to the chase, are they in favor of what you want to do, or are they not?
They're in favor, but I still have to do a full submittal, and that is a stamped architectural plan and submit my designs like colors and things for the outside and have it engineered.
And have you agreed to move the house towards the street?
Yes, sir. And what
As they have suggested?
Yes, sir. And what they were referring to is actually this copy that I sent in. I had a few, and that was the previous one. The one you have is the most up-to-date one that Ms. Working has, and it shows that I did slide the house more forward.
Okay. And this is yours. And number two, for the formal submission, is this what you've submitted?
I submitted that along with the fee and like a preliminary partial form, but they wanted me to submit the full package because they said it gets confusing when they get too many different forms in a row and trying to pull everything together.
Well, so are you seeking 15 feet or 10 feet? I can't tell.
10 feet from the property that's next to it. There's not another property to the right of me. I'm like the end one on the cul-de-sac, and then my parents have the property that I'll be building next to, and that's where I wanted to slide the 10-foot in lieu of the 15-foot to less encroach on the critical line.
So I'm trying to do just calculations, rough calculations here. You're talking about basically from what's established by law, you're seeking a grace, if I can use that word, of 30% from what the law would otherwise require. Is that
30%? Man, it sounds like a lot. I don't know.
50,
I'm not good on.
I took 50 feet and then 15 feet and divided 50 into 15 and got 30%.
So with it's 35 foot from the critical line is what I'm asking for, and then pushing it to the left in lieu of 15 foot, going to 10 foot. So I'd be closer to my parents' house, 10 foot off in lieu of 15, and then in lieu of 50 foot, it would be 35 foot from the critical line.
All right, thank you.
Mr. Brown.
Thank you, Mr. Chair.
excuse me, I got 14% one way and 30% the other way. Okay. All right.
I happened to notice on the email that you received that there's a comment about your 35-foot line and that there will be some cantilevering and things that are actually over that 35 feet. Are you aware of what that means? And
Yes,
that
sir. I am, and we've since, like the other second paper I brought you, we slid it forward even further. So that email, the one that's posted up there now is the most recent one. They were referring to the first submittal that I handed you with that email. So I've adjusted it for them.
All right, so what we're seeing here, I see a red line, and it kind of sort of overlaps some of the piers and things on this.
So those red lines are the critical buffer line.
Yeah, I understand that, but what I guess the letter from the HOA states that you're still hanging over with cantilevers, with roof overhangs or something. It refers to hanging over, and that I'm looking at this plan here, and you can't really tell, but if you zoom in, the red line kind of cuts into your house a little bit. So are we really a 34 and a half foot setback?
Which one are we are you, the one that you're looking at?
Whatever's in my packet.
With the pervious driveway? I handed you one with the email that showed what they were asking me to adjust after I submitted it. So I submitted one to them with some of the suggestions y'all asked me, and they did. And then they asked me to modify it, like slide it forward, do the gravel driveways, which appears up on the screen behind you.
I just didn't know if what I read on that letter
Yes, sir.
states that you are still over the 35-foot setback. That you're stating here is and requesting a 35-foot instead of 50, and you're still over that amount.
I slid that forward, I think 5 or 6 feet from where it was originally.
Did they see this plan? I guess that's the question, because I read the letter exactly how Mr. Brown read the letter, that it still is cantilevered over. This plan still cantilevered over the 35 feet.
I don't have the architectural drawings for that yet, because I was trying to get the variance for the 35-foot buffer, and I would, if they don't approve what I do, I can't build it.
What's the square footage on this house?
It's close to 3,000 square feet.
And what's the minimum for the subdivision again?
He doesn't have any room.
I think it's 2,000 or 2,800, 24 to 2,800 feet, somewhere in there.
Thank you.
Thank you, Mr. Chair. All right, so I'm going to break this down from my standpoint. You're asking for 4 things, and not putting them in any specific order, but for my vote, I don't really have a problem with the driveway and walkway within the critical line buffer, because buffers are additional setbacks, basically, and you're putting a pervious driveway. So really, I've been out to Paradise Island. I know that area somewhat. So that one makes sense to me. Reducing the 15-foot interior side setback, basically those type rules, I interpret them as you want to be a good neighbor. Well, your neighbors are your parents. Okay. That makes a lot of sense. Those lots out there are really, there's nothing uniform to them at all, and they're changing every day with the critical lines, with the way the water's coming in. So again, I don't have a problem with that one. Then you start looking at the critical line buffer and the critical line setback. Critical line setback at 50 feet, that's the one I'm really struggling on, because the setback for the critical line, those lines change. You get a high tide and you don't have the backyard like you used to have. So it probably could change today. And if you're going from 50 to 35, I applaud you for changing it from whatever they got denied before to try to make this thing go. But I'm struggling with that reduction of 15 feet from the 50, because I counted as 30% reduction, as Mr. Truslow did, I believe. So that's how I'm looking at it. So that leaves us only 70% of what the normal ordinance is. So I just think the house is too big on that back area. I'm really looking at this plan that's in our packet, not really glancing at that page yet, but I'm struggling to hit all of the criteria for the variances for the critical line setback variance, because I just don't think you hit that criteria. I think you're bringing this one on it's number 6. The need for the variance is not the result of the applicant's own actions. Well, you had a smaller house on the back side of it, or that covered porch that you have, which I totally get. I mean, I've got a porch that wraps around half of my house. I love it. I get it, but it's too big for right here. If that porch wasn't there, that's the 5 feet or 10 feet that you need, and it could be redone. The second variance reduced the critical line buffer by 5 feet to 30 feet for the decks. Well, we've already heard some testimony and questionings about these cantilevers, overhang and stuff. And again, I think it's all connected. I could support a motion for the bottom 2, for the interior side and the driveway, but those other ones, unless you've got something to explain to me why, I'm gonna struggle on that one. And I know we're gonna hear some testimony from other people that want to say they're gonna put down their sword into the area we should never go into critical line setbacks because of the nature and the overall goodness of why we have them. So I'm struggling with those two. Just if you want to tell me why, try to change my mind, now's the time on that one. But I'm just one of 9 votes. So
the house itself is a very narrow home, and I like to spend my time outdoors, so it's nice to have that addition on there to be able to have more square footage without it being like a full-on foundation down on the ground. Right. And it's a more natural to me, or I'm not a professional, but it is to me it would be less impedance to have a little more living area where you could enjoy the home without it being like a full-on foundation down below. And it's a narrow home, and it's a difficult lot already. And
it's a tough lot.
I know
right?
Every case is different with y'all. But I know that every home in there has received about the same, or most homes in there have received a very similar variance of 35 foot.
Yeah. We can't look at what somebody else got down the
yes,
street.
Yes, sir. I mean, I understand every case is different, but it's.
Thank you, Mr. Chair.
And we'll get back to you because you've already asked one question. Spread it around.
I'll wait my turn.
And thank you again for coming back tonight. The one thing that might be helpful here is just a reminder, do you know when these lots were originally platted by the county? And I can help you out if needed.
Yeah, well, they were, I think, before a lot of the buffer line wasn't done, maybe in 95.
Yeah, it's the early 2000s.
Okay.
And the way that the county allowed subdivisions to occur at that time was a little bit different than today. And so a lot of the property lines on this particular parcel, I believe I'm correct to say that they were based upon the critical line as it existed the day that this subdivision plat was created. And so your property boundaries are actually the critical line from the early 2000s. And what we've seen is what we're going to hear testimony here shortly, is encroachment of the marsh into what were uplands 25 years ago. Personally, I believe that creates the hardship, and it meets criteria number 6, just simply because you have no control over what was platted back in 2002, and now the lot is what it is. And if you apply the 15-foot, the 50-foot setbacks, in addition to that 35-foot buffer, if you tried to squeeze a house into an area that would not encroach upon the 50-foot setback area, the house would be, 15 to 20 feet wide? Is that correct?
Yes, sir.
And so you've got it stretched out to get to, I see 40 feet wide on the plans now, to push up against that 35-foot critical line buffer. So that's that 15-foot setback in between the 50 and the 35 feet. Personally, I think given the character and context of this particular neighborhood, given the constraints that we have to work with in this neighborhood, I think you've done a decent job of trying to reduce the impact, reduce the need for the variance. I don't see there's any way you could actually construct a building on this property without some kind of variance, because even access with the garage or with your driveway becomes something exceedingly difficult just to get into the bottom of the house where your garage is located. So I think I'd use this more as a statement than I did a question, but I appreciate the job that you've done to get it to this point so far.
Thank you. Thank you.
Thank you, Mr. Nelson. Now,
He addressed mine, so I don't have any more.
okay. Anyone on over here? No? All right, back to my right.
I had a question, but it's more for our esteemed attorney, and I'm trying to get to yes. I'm not sure I'm there. If we deny this application as it is stated here, could the applicant come back very quickly with something that may be more compatible with our existing ordinance?
The applicant just did that. We just went through that with this application.
Pardon me?
Sorry, nothing. No questions.
I
mean, you could bring a different application.
With a different application, with less of an impact on the environment than is currently existing. Is that correct?
Yeah, I mean, he could submit a different application, but
Okay.
this is his second time here.
All right.
I mean, I'm not going to testify, but
Okay. Got it. Thank you.
Any other questions? Thank you so very much for your testimony.
thank you.
Do we have anyone else to speak in support of this application? Do we have anyone to speak in support of this application? Do we have anyone to speak in opposition? Okay. Yes, ma'am. Please come forward. Please state your name and address for the record, and please tell us why we should deny this application.
Hi, my name is Susan Kershaw. I live at 3605 Berry Hill Road on Johns Island. I just want to take a minute to thank the staff and the board for recently adding conditions on the critical line cases that require the silt fencing along the buffer zone line, and the condition to maintain the land in the buffer zone in a state that complies with code. So thank you. And just in general, my concern about the buffer zone isn't so much rainwater overflow. It's about allowing the marsh to migrate. The Charleston Water Plan has highlighted the Paradise Island area of marsh as one that will die off as sea levels rise. Unless we allow the marsh to migrate upland. Buffer zones are what allow this. Without buffer zones, the marsh dies at great cost to the environment. Also, the land that was protected by it will become vulnerable to flooding, as will the neighbors, and it's a detriment to the neighbors and the public good because that erosion goes horizontally as well as vertically. Now, on this case, I understand the whole Paradise Island problem, and it's just a disgrace of that area anyway. But if this house was the minimum square footage, it would be hard. I'd be hard pressed to fight it. But as long as it's above the minimum square footage, this variance is totally a result of the owner's own actions. I have a concern about the driveway too, but that's another Paradise Island issue. But that's taking up so much of the buffer zone that it's just gonna impair the migration. But I don't. This lot is being sold for cheaper than other lots because it has an impairment to it. And if they want to build a big house, they should buy a lot that can accommodate it. This cheaper lot can only accommodate the minimum square footage, and even with that, they will need variances. But I wouldn't be opposed to those variances because of the whole history of Paradise Island. Thank you.
Okay, thank you so very much. Let me see if anyone on my right has a question. No? My left? Thank you so
Thank
very
you.
much for coming again today. Do we have anyone else to speak in opposition? Do we have anyone else to speak in opposition? Okay, so at this time, sir, you had a right to rebuttal if you so desire to use that right. So you're limited to 2 minutes. If you would, please state your name and address again for the record.
My name is Zach Carmel.
There you go.
Live at 4650 Cape Island Drive, Allendale, South Carolina.
Okay, when you address it, just address it this way, okay?
Yes, sir.
Thank
I
you.
will. And just this actually, I met with the, I've talked with storm water mitigation people, and that the pervious driveway will actually help with the water flow, just in any fears of that turnaround being worse. That's all I got to say.
Okay. Yes, Mr. Brown.
I got a question. She brought up about the minimum size of house, and maybe I just can't remember from the previous submittal and application, or how do you know what that minimum size is, and how far above that is your design so far?
It's roughly 400 square foot over.
So we're talking footprint, or are we talking overall square footage of the house?
Overall, like
so,
overall square foot.
So you're 400 feet more than the minimum
Yes, sir.
required. Okay. Thank you.
Anyone else? Yes, ma'am, Ms. Smith.
So do you understand the point that the point of the buffer is for the marsh to be able to migrate closer to the house? And would you allow the marsh to migrate where it can, or do you plan on trying to?
I do not want to interfere on any of that. I actually like the marsh, and that's why I like, kind of the being on the coastal area like that. So I would do whatever I could to preserve it.
Okay. Anyone else over that side? We're good. Thank you so very much for your testimony.
Thank you, sir.
Yes.
Thank you.
So at this time, the case is closed to the public. Board members, do we have any question of staff? Do we have any general discussion?
I have one comment.
Yes, sir.
I think Mr. Nelson's point of, I had forgotten about how old this plat probably is for Paradise Island lot. So I think his argument on what the original setbacks were versus what they are now is a very valid argument. I'm there on all four of the ones. So thank you.
What are your thoughts on the square footage?
I mean, there are majority of those houses out there are very large, and I'm not surprised that we're seeing a lot of houses variances apply for those lots, because there's just nothing uniform about any of those lots, and everybody's trying to build lots out there, build houses out there, and of course they want them because of the views. So again, I don't have as much heartache personally myself of going into buffers as I do, setbacks versus to buffers. So I think they've done. Could this be a little bit smaller? Probably, but I mean, this lot is really, really narrow. And I remember this case from the time before when he talked about his parents being that. I'd love to live next door to my parents. So I think it's a fair, from my standpoint, I think it's a fair use of the variance on this one.
How big is, just in context, I can't remember how big, I remember the case distinctly, but how big is this house?
3,000.
It's
3,000
square feet is what he's testified. The footprint, you can see it on the plans, is like 42 feet by 62 feet. So that's roughly 2,600 square feet for the actual footprint of the house sitting on the property. So if you think about scaling that back, even 200 square feet to get to the minimum, the reduction is so minimal. We're still here doing this.
Yes, ma'am.
Are we up for discussion right now?
Yes, ma'am.
Okay. I don't see how this could possibly meet criteria 3, which is that the, wait a minute.
She says she doesn't believe it meets criteria 3. Yes.
No.
She was getting ready to say why.
Did it unreasonably restrict? Is that the criteria you're looking for?
I withdraw my comment.
Okay. You heard that? She said she withdrew. Okay.
I'm prepared to make a motion if we're at that point.
Okay.
Mr. Chair, in the matter of BZA 0526000978, I would make a motion that we approve this request, that in making my motion that I find that it meets all 7 of the criteria that are necessary to grant this request, that there are extraordinary and exceptional conditions pertaining to this particular piece of property. And as I stated earlier, my main driver for approving this request purely stems from when the original plats and lots were created at Paradise Island. In fact, looking here in the notes, it was originally developed in 1995 with Phase 2, some additional work in 2001 and 2004. And the lot lines on this particular property were based upon the critical line at that time. And I think what we have seen here is how ruinous it is to base lot lines on critical line boundaries. But it was done in the early 2000s, and that's what we have to work with today. So that's going to be the basis of the majority of making the motion that I make. That 2, these conditions do not generally apply to other properties in the vicinity. Yeah, this is a little tough one actually because it applies to every single property on Paradise Island, which makes it makes the entire development unique. And I do believe that for this particular request, it meets that criterion. In fact, I don't even believe it would be possible to build a house at the minimum square footage that would meet the standards of that neighborhood and not necessitate some type of variance in order to fit a house on the property. For criterion 3, that because of these conditions, the application of this ordinance to this particular piece of property would effectively prohibit or unreasonably restrict the utilization of the property. And I believe we meet that criterion because, as I just stated, that the setbacks where the critical line sits today create such a small building envelope that the owner would have a difficult time even meeting the minimum standards for that particular neighborhood. So we meet that criterion. For criterion 4, that the authorization of the variance will not be of substantial detriment to the adjacent property or to the public good. We have 0 complaints. We have some preliminary indication that the HOA has approved, so I believe we meet that criterion. For 5, the BZA will not grant a variance, the effect of which would be to establish a use that's not otherwise permitted. Clearly, it's a residential use, so we meet that criterion. For criterion 6, the need for the variance is not the result of the applicant's own actions. I believe we meet that criterion because of when this lot was platted, as I stated previously, and how the critical line has changed since that time to encroach upon the building envelope that would otherwise be available on this particular property. And 7, that granting of the variance does not substantially conflict with the comprehensive plan or the purposes of this ordinance. Again, hopefully the owner will take great care to not impede upon the marsh further and allow for Charleston County to continue to have a healthy marsh. I do believe we meet that criterion, particularly when we implement the 5 conditions recommended by staff. And that is my motion.
Okay. Okay, we have a motion that's properly moved in second by, I heard a voice, but who was it? Neil. Mr. Neal, okay. Any discussion? Any questions? All those in favor, please indicate by saying aye and raising your right hand. 1, 2.
Aye.
Those that are opposed, there's 1. Thank you. So your application has been approved. I see the relief on your face already. So hopefully you'll sleep well tonight. Within 10 days, you'll get information from staff letting you know the next steps in the process. And good night, sir, and congratulations. So at this time, we're going to take a 10-minute break and then resume in 10 minutes. Thank you. Okay, let's get started again. Our next case up will be presented by Ms. Working. Case BZA 05-26-00979.
The applicant and property owner, Mary Anna Saavedra Espinosa, of the Dalen House LLC, is requesting a variance to reduce the required 3-foot interior line setback to allow 2 existing unpermitted detached accessory structures to remain on the property located at 215 Magnolia Road, and its TMS number 418-13-00140 in the St. Andrews area of Charleston County. The subject property and surrounding parcels to the north, south, and west are located within the low-density residential R4 zoning district, while the adjacent parcel to the east lies within the city of Charleston's jurisdiction. The specific variance requests are as follows. Accessory structure 1 is an existing unpermitted detached 15-foot by 17-foot deck requiring reduction of the 3-foot interior lot line side setback by 1.5 feet, resulting in a 1.5-foot setback from the eastern property line, and a reduction of the 3-foot interior lot line rear setback by 0.5 feet, resulting in a 2.5-foot setback from the northern property line. Accessory structure 2 is an existing unpermitted detached 8 by 8-foot shed requiring a reduction of the 3-foot interior lot line side setback, resulting in a setback of less than 1 foot from the eastern property line. A site visit was conducted by staff on June 26, 2026. This is the location map, the regulations for interior setbacks for accessory structures, the 300-foot radius map, aerials, the posting was a double frontage, and then this is the deck and the shed. Site plan and plat. Regarding the variance approval criteria, we stated that the request may meet 1 through 4, and 6 and 7, and it meets 5. The board may approve with conditions or deny the request based on the board's findings of fact, unless additional information is deemed necessary to make a decision. In the event the board decides to make a decision, the board should consider the following condition. 1, the applicant shall obtain all required zoning and building permits for the existing detached accessory structures to bring the structures in compliance with all applicable codes and regulations. Questions?
Any questions, Mr. Neal?
I'm curious how we got here. Did somebody get turned in? Did we find it? What happened?
I think they were applying for a SDR, and that's when we found that they needed variances.
So we found it on a site visit and said, what is this?
Right.
Okie doke. Thank you.
Any other questions?
So we'll have an SCR application after this one, Nikki?
Possibly.
Been nice, could have rolled it all in one.
Forwarded to Mr. Truslow.
Yes, sir.
There was an indication that 2 adjacent structures, this is under criteria number 1, 2 adjacent properties had structures that touch the property lines. How have they been dealt with, if at all?
See, that might be the parcel that's in the city, I believe. So it wouldn't have been dealt with by us. So I'm not sure how it was dealt
Okay.
with.
I just want to make sure we're treating everybody.
Correct.
Feeding everybody out of the same spoon of justice.
Right. Yeah. That lot is in the city of Charleston, unfortunately.
Any more questions of staff? Okay. Thank you, Ms. Working. Is the applicant? Yes, you are. You're here. Please state your name and address for the record, and please tell us why we should approve your application.
Good evening. My name is Mariana Saavedra Espinosa. I live at 925 Lango Avenue, but my husband and I own the LLC that owns 215 Magnolia Road. We used to live in that home. We moved in 2021, and we are out-of-towners, and we did a few things. The shed was an existing structure on the property, and when we moved in, we wanted to take the lot doesn't grow grass because it's under full canopy of some beautiful live oaks, but we wanted to be able to enjoy the backyard, so we built a deck. very much in conversation with our neighbors to the back who have a really old structure that I think is an old garage that backs up like right to their property line onto our property. We really like it because it's like a really funky looking wall, and we built the deck there. And then our next door neighbors, actually, we have a great relationship with them, and we when we built the deck, we created we shared the cost of of replacing a chain link fence with a privacy fence that would benefit both of us. So both of my adjacent neighbors, it is a corner lot, as you saw, were in full knowledge of us building this deck in the conditions in which we did. We continue to have great relationships with them. We were fortunate enough to be able to purchase another home up the road in Maryville, and we kept this home for my mother to stay when she comes to visit us. We have 2 small children, and it's great for her to be able to visit us for extended periods of time. And yes, when she's not here, and she comes usually for about 4 or 5 months a year, and when she's not here, it would be great to be able to pay for the expenses of this home. That is actually our child's college fund through renting it out. So should you be so graceful as to approve our variance today, we will be submitting an STR application. And the staff when I submitted my property plan, they said this is not going to work because you have 2 unpermitted structures here. You will need to apply for a variance, and that is what we did. So I would be so grateful if you approved, in part because it is sort of the custom in our neighborhood to have these. They're actually smaller lots. It's a really old neighborhood to have these structures really close to the property lines. I have great relationships with my neighbors. I think no comments were submitted because they have similar structures, and because we built that deck with their approval entirely. So and in the future, I will, of course, anything that I add to my property have the appropriate permitting. We're out-of-towners. We're actually not from this country, so I know that you cannot claim ignorance of the law to not following it, but we have learned from this experience, and in the future, we would absolutely follow all the appropriate procedures to have our structures up to code.
Very good. Very good. You seem excited a little bit.
I'm nervous. Everyone was so much more prepared than I thought. I was trying to look up the BISLA, or what is it, the LISDA, or what is the acronym for the plan? The zoning. The
ZELDAR.
The ZELDA. I was like, oh my goodness, I need an outline. So I am a little nervous, but I presented my case.
You did, and very well so. Let me see. Mr. Jordan has a question to start off with, okay?
For sure.
What country is home?
Colombia, in South America.
Okay.
Yes, sir.
And don't be nervous. We're just everyday people, too.
I'm sorry?
Don't be nervous. We're everyday people, too.
Yes. I'm happy to see that my fellow county dwellers are also here.
Ms. Smith?
Wanted to clarify. The building, the accessory structure, that was already there when you purchased the home?
So the shed was the one
Right.
that has a roof was there when we purchased the home, and I don't know when that was built. I think a long time ago.
So the only thing that you added was the deck?
The deck, correct.
Okay.
Yes.
Thank you.
Yes, ma'am.
Any more questions on this side? No? Any questions on my right? Okay. Thank you so very much. I do appreciate
Thank you,
your time
folks. I
coming out
appreciate
today.
you taking the time.
All right. Thank you. Do we have anyone else to speak in favor of this application? Do we have anyone to speak in favor? Our numbers are getting lower, excuse me. Do we have anyone to speak in opposition? Anyone to speak in opposition? Very good. Case closed to the public. Board members, do we have any question of staff or any general discussion? Very good. At this time, I'd like to kindly ask for a motion to approve or deny this case. Yes, sir, Mr. Neal.
Yes, in case BZA 0526000980, I make a motion for approval of this variance to to reduce the required 50-foot street side setback by 42 feet to 8 foot. I feel that it meets all 7 criteria. There's nobody here in opposition. It is an existing structure, but it doesn't seem. Whoa. I'm sorry. I apologize.
Thank you.
Thank you. Scratch that. That's why I got my glasses on. Case BZA 979, right?
Yes.
979, yes. 00979. Variance request to reduce 3-foot interior lot line setback to allow 2 existing unpermitted detached accessory structures. There's no opposition to it. It's already been built, but as long as we include staff comments, I'm fine with moving forward with a motion for the approval. I feel that it meets all 7 of the criteria. There are extraordinary exceptional conditions pertaining to this particular piece of property. I feel it meets that criteria. Criteria number 2, these conditions do not generally apply to the other property in the vicinity. Criteria number 3, because of these conditions, application of this ordinance to the particular piece of the property would effectively prohibit or unreasonably restrict. I don't see how it impacts anything on the outside. We're just going, it is a large variance, but there's just no impact whatsoever, and there's been no testimony against it. Number 4, the authorization of variance will not be a substantial detriment to the adjacent property, plus it's already there, and we don't have any comments on record that it's been a problem. Criteria number 5, the Board of Zoning Appeals shall not grant a variance to the effect of which would allow the establishment of the use not permitted in the zoning district. Didn't catch the use of this, but I believe it's some type of barn structure, outdoor structure, so it's not going to have a problem in the zoning district. Granted, criteria number 6, the need for the variance is not the result of the applicant's own actions. Obviously, this property was bought with it already in place. They did make some improvements to it, but again, not their own actions. And criteria number 7, granting the variance does not substantially conflict with a comprehensive plan. Again, there's no opposition on record for this, so I'm fine with this application. I would like to include all of staff comments for my approval motion.
Okay, so I have a motion to properly moved and second. You have the question or discussion?
None at all. I was just going to say gracias por venir. He estado en Bogotá, en Medellín, Cartagena.
Said the owner of El Jefe.
All right. We got all that out now?
Yeah, we got it all out.
Okay, very good.
Want that included in the record?
No.
All those in favor, please indicate by saying aye and raise your right hand. Aye. It's unanimous. Congratulations, your application has been approved. Within 10 days, you'll get information from staff letting you know the next steps in the application process. Thank you so very much. Okay, so our next case is case BZA 0526-00980. And
The
Ms. Workman.
applicant and the property owner, Robert Rothier, is requesting a variance to reduce the required 50-foot front street side setback by 42 feet, resulting in an 8-foot front street side setback for an existing non-permitted detached accessory structure stall to remain on the property located at 2515 Breakaway Trail, which is TMS number 316-0000172 on Johns Island in Charleston County. The subject property and surrounding parcels are located within the Rural Agricultural AG8 zoning district. The 15.9-acre property contains a single-family residence and a barn that were permitted. The property also contains several outbuildings, stalls, sheds, and a shipping container. All these accessory structures, except for the one associated with this request, have received retroactive zoning permits. In the applicant's letter of intent, they explain, quote, "We built a livestock run-in shelter in one of the pastures, and after the fact, we learned it fell into the setback rules. The location was picked because it allows line of sight from both the house and the barn. We are a private farm on a private road." This is the location map, the zoning ordinance setback requirements, 300-foot radius, aerial. We posted the property on June 26, 2026. This is the stall, the barn entrance, and then the trail. Oh, breakaway trail, sorry. And the site plan again, and the plats. Let's see. regarding the approval criteria, we stated that it may meet 1 through 4 and 6 and 7, and it meets 5. The board may approve approval conditions or deny the request based on the board's findings of fact unless additional information is deemed necessary to make an informed decision. In the event the board decides to approve the request, we recommend the following condition. 1, the applicant shall obtain all required zoning and building permits for the existing 23-foot by 24-foot stall to bring the structure into compliance with all applicable codes and regulations. Questions?
Any questions? Yes, Mr. Brown.
Not that it has any bearing necessarily on this particular case, but did we see one close to this property before?
Have you guys seen one?
Just some of those pictures look very familiar to me, and am I mistaken?
I don't think I've had anything on Breakaway Trail. Do you remember, Genesis? I don't remember anything on Breakaway Trail.
Okay, it just,
Mount Pleasant.
apologies for misunderstanding, but I swear this looked very familiar, so.
It's on
I wasn't
John's
sure- I
Island.
was confused a little bit as to whether we'd seen it before.
No, not this particular
All right,
property.
so it's a whole new case.
Yeah.
Okay.
A lot of John's Island looks alike.
Yeah.
Anybody else? Anyone else? Thank you, Ms. Workman. Would the applicant?
I
Oh,
wanted to
go
ask a
ahead.
How was this discovered?
They came in to do some permitting, and then they were able to get all the retroactive permits for everything else because they met the setbacks, but not this.
Was it a self-report or?
Well, I don't know that it was self-report, but they came in to get permits for other things.
Okay.
They could probably tell you more.
Did they say why they didn't get a permit for this?
I think they just
Structure.
didn't know that it would need permits or that.
I mean, did they have a builder or did they do it
That
themselves?
I don't know.
Okay.
Yeah.
Well, all right, I'll
Yeah.
ask them. Thank you.
Okay, is the applicant present?
Yes.
All right. Please state your name and address for the record, and please tell us why we should approve the application. You can lift that a little bit higher if you like.
As long as you can hear me, we're good.
Very good.
Robert Ruthier, 2515 Breakaway Trail, Johns Island, South Carolina, 29455. To answer Mr. Brown's question, yes, you probably did see a property on there. Lot 1 at the front needed to ask for a variance because they could not fit their house on the lot without getting a variance. So pictures are familiar. Yeah, to answer the questions about why we didn't permit, I didn't know livestock run-ins needed permits. It was ignorance on our part. Upon requesting an STR, which we'll be back for, they pulled up the visuals, wanted the on-site as-built, and informed us that the run-in sheds needed to be, which we came in and started the retro process on. And that's when zoning told us the one was too close to setbacks. So we have zoning permits for all the other buildings, waiting on this zoning permit to go into building, to get building permits for them. We've had no plans for these because we've raised livestock most of our life, so we build them on demand. But I did get with an engineer and have him, send him pictures, describe what we built, and I have an engineered letter to present to building saying that the buildings are built to code and everything's good with them. Just didn't know that we had some issues on needing to get permits at the time that we built. And we built them all ourselves. I had a builder for the house, the barn, and the other structures that I worked with, but I built the run-in sheds myself.
Okay. You finished?
I'm ready for rebuttal, I guess.
Okay, let's see if we have a few questions. I'll start off with one. I was looking in your pictures that were presented. Was that a llama?
They're alpacas.
Alpaca,
We have
that's what I'm
26 alpacas.
Okay. What else are you raising out there?
We have 6 chickens, basically for ourselves. And raising-wise, just the alpacas, but we do have a miniature pony and 2 miniature donkeys. We use them. We adopted them from a friend that was moving and needed to have a place for them, but we do rotational grazing for all of our pastures, so we have 8 paddocks, hence the different run-in sheds for shelter for all the animals. So we have 4 groups of alpacas. They rotate pastures every 4 weeks, and the donkeys and the ponies rotate behind them in their empty pastures, and together it helps create parasite control because they don't share parasites. So by letting equine graze, they eat the parasites that were shed by the alpacas, and the alpacas eat the parasites that were shed by the equine.
Good man.
That might have been more information that you wanted, but
Good question. Any questions on my left? Mr. Jordan?
well, I mean, Waylon could, we could put a horn on him and he can.
Yeah, that's a poor man's.
We did have a super soft birthday party once, and out there, so.
Poor man's uniform.
Questions on my right?
I'm just curious, because I get asked this quite often by builders that apply for permits. This was, as I understand, an innocent mistake on your part. And approximately how much was the cost of the construction of the shed we're talking about?
Well, because labor was me, and we also have a sawmill, so I milled most of the 2x lumber that's in the building. I'd say estimated cost is around $1,500 to $1,600 in metal screws and stuff, roughly.
Okay.
Probably would be more in a $2,500 to $3,000 build if you were actually contracting somebody to do it.
And then the second question, more concern to me. I want to make sure that this isn't going to have. I want you to address, if you would, please, address the potential adverse impact on your community or your neighbors. I don't know that I see one, but if you could address this for me, because this is about an 84% reduction in what the law requires.
No, our neighbors, it's a small farm community. It's a gated private road. Breakaway Trail is a private road. We maintain it. There are 10, I guess you would consider them farmettes. We are the one of only 2 working farms in there. The person behind us with the very next lot, they have boarding for horses. So they're the only 2. Everybody else just has property. Some of them have chickens or horses or stuff themselves, but they're not actual working farms. The neighbors across from us, they have young children. Their daughter absolutely loves it's right there because she has her favorites and knows the names of them and comes over to the fence and shows all of her friends.
Excuse me, I don't mean to interrupt you, but to cut to the chase, your neighbors don't have any heartache with you doing this.
No,
You've heard no complaints.
I've talked to everybody. I'm a member of our HOA board. Actually, was just talking to the president last night. He said good luck. Asked if anybody had sent anything in. I didn't really get a reply. I figured they all just kind of stayed in their lane. That's kind of where we're at. But yes, everybody in verbal conversations, nobody has a problem with it. They're all in support of what we do. Everybody brings friends and family to the farm to see the alpacas. It's a very open.
And to just finish up with this, and then if you would have certainly been willing to move it if you had to, if your neighbors were upset, but there's no harm, no foul, so to speak.
If you'd have told me I had to move it, I was going to find a new location for it.
Thank you.
But as they said, locations of the buildings were picked. So for line of sight, being able to see them in their shelters, this time of year is a very watchful time for alpacas because they grow fiber like sheep and everything else and have to be sheared. But this is the hot season, so we like being able to look out and see, are they in there by the fans? Is everybody inside? So every building, and if you look at the buildings, they all match. Everything's tied to the house. Everything's everything's a green and black theme, but our house, our barn, all the run-in sheds, everything was constructed for the aesthetics of, being a nice farm.
Thank you.
Any more questions? Thank you so very much for your testimony, sir. Do we have anyone else to speak in favor of this application? Anyone else to speak in favor? Do we have anyone to speak in opposition? Anyone to speak in opposition? Thank you so very much. This case is closed to the public. Board members, do we have any questions of staff? Do we have any general discussion? Very good. Is it possible I can get a motion to approve or deny this application?
I'll make a motion to approve.
Yes, sir.
Mr. Chairman, in case number, this is 780, Pending in case, 980. I make a motion that we approve the request for a variance. In this case, the approval criteria are set forth in Zelda section 3.10.6, and there are 7 criteria. If staff has a recommendation, and they do, I would make make my motion contingent upon the staff recommendations. Number 1, and I'm just going through these so there won't be any question. There are extraordinary and exceptional conditions pertaining to this property. It's a very small, I guess that's subjective, but it's a small farm, if you will. The property functions as a private farm. They've got animals that they need to be careful to maintain them and to protect the public. And I've seen the photographs, and it looks like beautiful property. This is located 8 feet from the property line. I understand that this is a substantial reduction in what would ordinarily be required, but it's on a private 50-foot ingress, egress with a utility easement. And it's and the recorded plat identifies this as a farm road. Number 2, the response: these conditions do not generally apply to other properties in the vicinity. I think that is clear. This is zoned as Ag 8 zoning district, and not all properties appear to front on a privately maintained farm road. Number 3, because of these conditions, the application of the ordinance to this piece of property would unreasonably restrict a safe use of the property, especially for the animals, given line of what I understood to be line of sight. Number 4, and I hope I'm not going too fast, but it appears this is a clear case where approval should be granted. This will not be a substantial detriment to the public good. In fact, it appears to be attractive, and the neighborhood children can enjoy the animals. Number 5, this variance does not allow use that's not permitted. This is obvious from the law. Number 6, criteria 6. This is a difficult one for me, but I would find that this is not a result of the applicant's own actions. This was placed innocently to support a farm operation and to provide for the protection of animals. And from what I understand, this is basically a case of self-reporting. Number 7, granting of the variance does not substantially conflict with a comprehensive plan. In fact, I would find that it would be consistent even though an error had been made. So that's my motion, subject to the conditions, if any, recommended by staff.
Okay, we have a motion that, okay, thank you, Ms. Smith. We have a motion now that has been properly moved and second. Any general discussion?
Makes me wonder if we could revisit agricultural zoning and make sure that it supports farms. We lose so many farms every year, and it just seems like a working farm might not need all these restrictions.
Any other questions, comments, statements? All those in favor, please indicate by saying aye and raise your right hand. Aye. It is unanimous. Your application has been approved, sir. Within 10 days, you'll be getting information from our wonderful staff letting you know the next step in the process. Thank you so very much for coming. Very best of luck in your business, and good night, sir. Okay. Our next case for tonight is case BZA 05-26-00981. Mr. Carlisle, we have your attention.
Thank you.
You have our attention, excuse me.
The applicants and property owners, Robert Franklin and Donna Franklin, represented by Alexander Franklin, request a variance to remove a 35-inch DBH diameter at breast height grand southern red oak tree to allow the construction of a proposed single-family residence located at 925 Hughes Road. TMS number 28700000329, in the St. Andrews area of Charleston County. The staff arborist evaluated the 35-inch southern red oak tree and classified it as a grade B specimen. The subject property and adjacent parcels are zoned low density residential R4. The applicant proposes removing this tree to construct a single-family residence on the subject property. A site visit was conducted by staff on June 26th. And these are the site plan and a zoomed-in version of the site plan. It's the property location within the county as a whole, the ordinance requirement, the radius map, aerials of the property. The property was noticed on June 26th. These are pictures of the tree. And this is the subject property and Hughes Road. And again, this is the site plan, zoomed in site plan, the recorded plat. And regarding the approval criteria, we stated, staff stated it meets number 5, may meet numbers 1, 2, 4, and 7, and may not meet numbers 3 and 6. The board may approve with conditions, or deny a case based on the board's findings of fact, unless additional information is deemed necessary to make an informed decision. In the event BZA decides to approve the application, staff recommends the following conditions. 1, the applicant shall mitigate the removal of the 35-inch DBH Grand Southern Red Oak tree by one of the following methods. Submitting a mitigation plan for review and approval indicating the installation of canopy trees no smaller than 2.5 inches in caliper, equaling inch-for-inch replacement, and or depositing funds into the Charleston County Tree Fund as described in Section 9.2.6 of the ZELDAR, or a combination of both A and B. Mitigation shall be completed prior to tree removal. 2, tree barricades constructed of chain link fencing shall be installed around all protected trees within 40 feet of disturbance prior to any construction pursuant to Section 9.2.4 of the ZELDAR. 3, the applicant shall retain a certified arborist to monitor and treat all grand trees within 40 feet of disturbance throughout construction. A copy of the tree preservation plan shall be submitted to zoning staff for review and approval prior to zoning permit issuance. And this is the staff recommendation. And be happy to answer any questions.
Yes, sir, Mr. Neal, you have a question.
Thank you, Mr. Chair. Go to the site plan, if you don't mind,
Sure.
please, Mr. Carlisle. So I see the 35, go back to that one. I see the 35-inch, I guess, red oak. That's the one that they're asking for the variance. They're not asking for anything on the 24 or the 27?
Correct. The others are there just because they're grand trees that are in this.
But they're not removing, or there's no encroachment variance being asked for either one of those?
No, sir.
Okay. Is the 35-inch, well, I'll hold the rest of my questions for the applicant. I'm sorry. Thank you, Mr. Chair.
Anyone else? Thank you, sir. I appreciate it. Is the applicant present? All right, please state your name and address for the record and tell us why we should approve this application.
Alex Franklin. I'm representing Robert Franklin. My address is 1539 Keswick Drive, Johnstown.
Your name, your first name again?
Alexander Franklin.
Thank you.
To answer the question that was proposed about the 24-inch pin oak, that is been reevaluated by a certified arborist to be actually a half-inch short of the full size of the 24-inch diameter for the tree. So, and which that letter has already been submitted to zoning, and zoning is already Kyle has approved that letter and said that was okay. And then, so we started drawing this house before we got a tree survey, and so we put it in the largest spot of the lot, and we have a very interesting condition that we have this drainage easement from the county and the power line easement on the other side, and then we also have the flood line right in front of us. So we're kind of very much wedged in this spot to try and fit a single floor home. And so, we tried to adjust the house the best we could to keep as many big trees as we could, but the 35-inch red oak in the back ended up being kind of in the way. For us trying. We did suggest changing the staircase the front staircase in order to give more room for the tree. But as Kyle explained to me, any change inside of the canopy of the tree is considered, encroachment on the tree, and we would basically have to be almost 100% encroachment because of fill dirt around the tree. As far as we can, with the best that we can do for that tree. We are proposing that we would replace inch for inch and greater the amount in replacement trees around the property. It is a 5-acre property, and we plan on putting many large oak trees, 2.5-inch and greater diameter, out to try and make up for this tree. We like the trees. The trees are great. This is just kind of one that's put us in a hard spot in this instance. Other than that, I think that's most of what I had.
All right, very good. So I already have a raised hand over this. I'll let him start. Mr. Neal?
Thank you. Thank you, Mr. Chair. Before I ask my question on the 35-inch, so you said the 24-inch oak, is that the back of the house or the front of the house?
That's the back of the house.
So the back of the house is where the 24 is. That's what I thought. So it's really not 24. You're saying you've got stuff that says it's 23 and a half.
Yes, I have a letter from...
No, that's fine. So my question is the 23 and a half inch tree coming down?
Yes.
Yeah, okay.
It is
fine. I got
underneath
you.
the deck.
I got you. No problem. So I'm really just focusing on the 35-inch. So I am not an architect at all, and I will not attempt to redraw. But this 35-inch, I fully don't see why you can't have one entrance instead of having two stairwells. You can have a stairwell down the middle. It just seems to be a luxury that you're trying to have there. And I understand the filling and the area around it. I would much rather see an encroachment permit variance than cutting down a 35-inch tree because it's in the way of the base of your second stairwell. So criteria number 6 says the need for the variance is not the result of the applicant's own actions. And that's a high bar for you to have a second stairwell. I'm not lecturing, I'm saying that's I need understanding of why you qualify for that.
Yes, so we also sent over a second drawing with a different set of stairs that actually comes closer to the building and is farther spread out and comes out.
Working. Do we have that?
I don't know if they have it. I mean, we sent it at one point.
Yeah, so we have to vote on something that's in front of us.
There.
So, I mean, there's other options to you. You can defer and bring some other stuff, but right now, and I'm just one vote. But I'm just telling you that you're asking for a variance on something that looks like you could redesign a stairwell and probably wouldn't need a variance, or maybe you come back and say, hey, we need an encroachment, but we would like to save the tree. And I get it's a double tree, it's a grade B, it's not the best thing in the world, but that's a hard bar you're trying to jump over. So I don't know where you are, but we're voting on this unless you have something you're submitting right now to us that we can review. That's up to the staff.
I do have the drawing, the revised drawing, but the other option that can be submitted.
I don't know. I mean,
So while we're waiting on that, how large is your lot again, please?
It's 5.2 5.6 acres. And
Tree encroachment.
that
Need to move that thing.
Charleston County drainage easement basically bisects the entire lot at a diagonal angle. So either at both ends there's a wide section on either side of the river or either side of the drainage creek, and this is the wider of the two.
Let me go to Mr. Jordan and I come back, okay? Please? Mr. Jordan?
So you might remember watching earlier in the meeting when we was talking about taking a tree down. And those people struggled so and kept saying, no way, we got to do this. And if I remember correctly, this wasn't their first meeting. And lo and behold, here they come in here with a lawyer who says, we got it figured out. Ain't there anything y'all can do to save this tree? I mean, I'm listening to what my colleague is saying, and I think he's making a pretty good point. Could you bend a little bit to save the tree?
Yeah, so we that's why we sent that over to.
What about what he suggested? Y'all willing to consider that?
Let's see if we can get an understanding of what's on this drawing.
Mr. Brown, go ahead.
Thank you, Mr.
Yes, sir.
So this drawing, if I'm looking at it correctly, shifts these stairs, it widens it apart, so those two landings that come down are significantly shifted from what we're looking at here on the screen.
Yeah, it moves.
They're closer to the house, and they're pulled apart. So now you're showing an encroachment. If, after hearing these comments about our not wanting to remove this tree if at all possible, if there's a way to save it, and knowing that this drawing is here, would you be willing to withdraw and maybe resubmit this with a different request
For encroachment.
for encroachment and saving the tree rather than removing it? Is that just, looking at this, it looks like it's an option. Is it something that you might want to consider?
Yes, I mean, it would be an option.
Well, let me say, we can't do that here
Yeah,
because
yes,
we're
yes,
reviewing this. So it's up to you to decide how you want to move forward with it, would be my understanding.
Give me 1 second to discuss with.
Mr. Brown, would you pass the one down?
If I may shed some light on this, that site plan would have to be reconfigured a great deal in order to.
Hold on. Go ahead, Mr. Foster.
Because as it stands now, that tree has like 98% encroachment per that plan. I have yet to see this new plan. Maybe I have seen it. It's been a long time. That driveway would have to go. And there's encroachment on all three sides of that, on every side of that tree. They need to shift that driveway considerably or lose that entire side of the driveway in order to not encroach more than what we allow.
There's a lot of land out there.
There's a lot of land out there. And if I can remember from my walk of the site a few weeks back, there's a good deal of larger trees towards the front of the property. Just from what I recall, this tree survey only shows the trees in the back of the property, but from what I recall, there were more larger trees towards the eastern side of the property.
I don't know if this is an owner question or a you question, but are these peas, and a lot of those peas out there, those pine trees? Yes. Okay. There's a nice red oak in the middle of I'm guessing gums and pines and a bunch of not as quality specimen trees as a red oak would be.
I think so. Right. I say that property was probably cleared within the last 40 years ago. So you get a lot of trees that are not of high quality, grow back really fast, very spindly, very tall.
Mr. Chair, may I ask a question? Oh, I'm sorry, Mr. Brown.
It's a staff question. I guess.
So I was going to ask, before the gentleman responds to what he might want to do, how staff would like to handle circumstances where this is obviously, he's trying to attempt some type of modification. Does staff prefer to have a withdrawal or a voter up or down on this application, or defer to where they can update just with the site plan and have review? I'm trying to understand what's the proper procedure moving forward. I understand we've got to vote on this up or down, or this gets withdrawn. But if there's an allowance for them to be able to just resubmit a site plan to save the time and not have to go through the whole process of another application, that might be a consideration. I just don't know how staff handles things, kind of where I am.
You want to answer that, Ms. Working?
It would just depend, like, so if he still needs a variance for removal, Kyle, are you saying the encroachment would be so significant it would still be considered a removal? Or we just don't know because the plan, we don't have the revised one.
Wouldn't
This
be a
one
removal, it'd be an encroachment.
would still need a variance for encroachment. This is significant encroachment. Talking about grade changes on all sides of the trees still.
Right.
You know, if they didn't change the grade with this little area given to the tree in the middle of the driveway, that it'd be a bowl. Just hold moisture and rain.
Withdrawal.
So it still would be like considered a grand tree removal?
Yes, ma'am.
Yeah.
Encroachment.
Yeah, but at that point, it's a different, it's either a withdrawal or we have to vote it up or down, is what it sounds like with a new application, if it does, can go through.
Would that have a percentage, it would be, we would consider it a removal.
And you're saying removal, you're talking about the tree?
You said removal? Did I hear you say that?
Mhm.
Of the tree.
Right, like, do you know the section number, Kelly, that I'm talking about, 924C?
Not E and C.
Yeah.
Can't could the driveway and things around the tree shift or change potentially to limit that encroachment?
Of course, this driveway, I'm not an architect, I'm an arborist, but just going off of this driveway, in my opinion, is massive.
Yes.
You know?
And I guess that's what in the current layout, it would certainly encroach a lot, but with some changing of the design of the driveway.
Very large changes.
Sure.
You know, for instance, if they were if the driveway didn't curve so close to the tree, if it went out in a loop, which would look ridiculous, but it would work. You know, a lot of things that happen in the site plan that would make it work.
I'm sure a good
I'm not the
civil or
applicant.
landscape person could figure something out. That might
Yes,
work.
sir.
So, Mr. Chair, that I mean, it's a voter up or down or, okay.
Ms. Smith, I just want to give her an opportunity. Yes.
For the plan that we're looking at in this application, is there a reason why you situated the driveway where you did? Did you do it to avoid taking down other trees, or did you leave significant trees standing on the property?
So you're talking about the driveway on the north side. That already cuts right on the line of the easement from the power line company, and all of that past that, it is very wet. Like you walk in it and you sink. So we tried to keep it as tight as we could, because then we're not going out into all of that and not into their easement, which then would require getting permission from them.
Okay. You had a follow-up. Go ahead. You turned your mic off.
So I know this application is for this tree, but I'm trying to understand if you made any allowances in the site plan to save trees. Did you save
Yes,
trees?
so we're trying to save all the trees up the front, towards the OCRM line. There's several larger hardwood trees, and then basically everything towards the back half of the property, towards the front side of the property, towards the road. All those pine trees, all those gum trees, all those, we're trying to keep all of them. The driveway that is there, most of that was already existing from when they originally cleared the lot. So we're sticking to that and going across. So we did take an effort to try and minimize taking down trees, unlike the neighbors who clear-cut the entire lots. So we do, want to retain as many trees as possible, and large trees for privacy and for, a nice atmosphere and nature.
Okay. I guess the question I want to ask you, do you understand the dilemma that is
Yes.
in front of you now?
Yes. So sounds like he's saying that no matter what, even if the driveway were to move, that we would still have to bring grade up because are going to end up with a bowl, and we will end up with water sitting around the tree if we bring all the land up around the tree, and that in that way we are have too much encroachment for the tree to be considered savable, where it would have to be. Then we'd be back in the same position where we'd be applying for a permit to take it down.
Okay. At this time, how would you like to move forward?
We'd like to proceed with a vote. I think my father wants to say something, though.
Oh, okay. Okay. Well, yeah, we hadn't gone through the whole preliminary, so you got every right to do that. So hold on. Do we have any other board member that has a question for this representative?
Yes, thank you, Mr. Chairman. I'm not sure whether this is for Mr. Foster or for you, but I'm trying to put this in perspective, looking at the photographs and what we have before us. We got a basically 5+ acre piece of property. We're not talking about a 20-foot right-of-way or road. We're talking about a relatively large residential parcel. What are the plans for the rest of the property? They're going to cut down all the trees? Are they going to be pasture?
No.
So they're trying to preserve. They're trying to preserve as many trees as they can.
Yeah, they want to keep it as well as possible.
In context or perspective, how many trees that are on site have the potential to become grand trees versus pines and gum trees and palm trees, things like that?
So we only had a small section of that surveyed. There are several smaller ones that are already around the perimeter of the house, and then along the driveway, there's actually already probably 10 or 12 heading out of the property that are not big right now, but growing. And then we plan on planting more larger.
For me, this is just for me alone. One of the things I'm trying to consider is whether this is going to be a relatively de minimis. I realize it's a grand tree, but is it, in the overall perspective, is it going to be have a de minimis impact or great? You're going to have to plant. You're proposing to mitigate. So sometimes more becomes less, or less becomes more, depending on how you look at it. What do you think?
I mean, we're trying to make the best out of a not great situation. Nobody likes cutting down big trees. I mean, I run a wood shop. I like working with trees and everything, but this one is just kind of in a tough spot. So we're going to try and mitigate that by replacing with extra trees, and it's in the back of the property. So it's not of.
This is more. I guess this is more of a comment or an observation. But I would hope that we would we would feed everybody out of the same spoon of justice as well as we could, and that we would consider trees no greater than we would consider invading the marsh or allowing variances. That's just a comment. I've had a tree farm, so recently sold, but it was much larger. But I'm sensitive to the trees and the concerns that have been expressed. But in the overall perspective, I'm trying to figure out how this is going to impact on the community as a whole.
Okay. Thank you. Mr. Nelson has a question for you.
All right. Thank you for enduring the grilling. Mr. Carlisle, can you pull up the plat?
Sure.
Just want to make sure I'm looking at this correctly. So this particular piece of property, it's 5.8 acres, but you guys are proposing to put the house on, we can't really see that very well, but there's a drainage easement that bisects the property, correct? And so on the north side of the property, you got 2.3 acres of high land, and on the south side of that easement, you got 2.8 acres of high land. And where you're proposing to put the house is, I don't know if my colleagues can see. I don't know if y'all can point to it.
It's basically on the north side.
Really helpful. And so you are trying to squeeze this house into the widest portion of the property that you can that's closest to, basically your marsh views back there. Is that accurate?
Yeah, into the widest part of the property that actually does have a view, and it's not at the front line of the road.
And so then the remainder of that, the 2.8 acres on the south side of that remain undeveloped, right?
Yep, it'll remain wooded besides the driveway, and same with the front side of the side the house is on as well.
Okay. I do get the idea that the driveway could be shifted some, to create a tree well, create some drainage or something like that to save this 35-inch red oak, but actually understand the placement of the house much better now. Thank you for walking through me with that.
Mr. Neal,
Thank
had a
you.
question?
Yeah, just one quick follow-up. So the 23.5-inch, whatever oak that is, I don't know, that is no longer a 24-inch.
Mm-hmm.
Why are you cutting that down?
It is that dotted line is the back deck.
Is the what?
Is the back deck where the
back
dotted
deck.
line
So
is.
it's in the way of the back deck. So if that tree grows another half inch and gets to 24, you'll have to come back for a variance, right?
Hopefully not. Hopefully it doesn't grow that fast.
We're not and I apologize for the grilling too.
That's all good.
It's just, we really try to save trees here, and I get it. I do. I think that there's another way to do this. I know you're cramming a lot in there. How big is the house?
It's 3,200 square feet.
3,200 square feet?
Yeah, single floor so that they can, live in place, age in place.
You've got some issues there with the drainage easement, the power line easement from Dominion Energy. I understand that. So I understand the location. I just don't understand the location of the steps and, not being an architect, and I wouldn't even redraw it for you. I would just, I'm having a hard time getting over number 6. So I'm probably going to be a no vote if since you've asked for us to go up or down tonight, which is clearly you're right. And I would, if I was in your shoes, I'd be doing the same thing. I think there's another way. People are a lot smarter than me to do that stairwell and figure out. I have no idea what it would take for the drainage and a tree well or an encroachment, but I sure would hate to vote for something and give you permanent access when we could have looked at another option. If you come back and say we tried all of this different stuff and the only way we could do is an encroachment of 50%, which is probably going to kill the tree anyway, that's an argument I'd like to have. But without having that argument right now, I'm probably a no on it. Just letting you know. Thank you, Mr. Chair.
Quite well. Anyone else have a question of this applicant? Yes, sir.
I know your tree survey only encompasses where the house is proposed, but do you have an idea of how many grand trees sit on the overall 5.8 acres that you're avoiding?
I couldn't tell you exactly. I know there are quite a few. For grands, there's probably another 3 or 4. More than that? Maybe up 10 or so.
And maybe your father can add some more info to that too.
Yeah. He's been on the property quite a lot. So
all right.
There are quite a few, and I know there are some towards the front of the property as well. So, but again, a lot of the infill is those pines, which are quite large.
All right. Thank you.
All right. Thank you. Let's bring your dad up, I guess. If we don't have any more questions for you, give your dad a chance to get on the grill. Please state your name and address for the record, sir.
Robert Franklin, 1323 Queens Road, Charlotte, North Carolina, 28202.
Thank you, sir.
My wife and I purchased this property a couple of years ago. When you went on it, you could not see anything. It was covered with bushes and thousands of sweet gum trees. We're in the process of culling those out, leaving everything but the sweet gum trees so we can then replant other trees because we consider the sweet gum trees a nuisance. We had one in Charlotte that was 36 inches. We took that out because it was dropping stuff everywhere. We replanted two maples in lieu of it. We plan on planting many more hardwoods on this property than required. Our neighborhood encourages that because they like to have the properties covered. I like to have my property covered. The reason I would like not to remove the driveway is because we spent lots of time working on the design of that driveway. Additionally, if you have the tree near the driveway, it's going to buckle the driveway, which is a major concern, which will also cause a problem with the tree's ability to survive. I would much rather have trees growing on the property that have a chance to survive, many trees, as opposed to this one tree. I will say this tree will not go to waste. When I cut a tree, in fact, my wife will say I probably shouldn't have. That sweet gum tree is now lumber. This tree would probably become lumber and become some kind of furniture. So it would not be going to waste. And again, we do plan on planting numerous trees, particularly at the front part of the property where we need to put a screening to the road. I'd be happy to answer any questions anyone has.
Done so eloquently, sir. Thank you. Any questions on my left? Mr. Jordan?
So, I guess, I don't know if I can ask you this or not, but do you understand yourself and agree that you want to up or down vote tonight? Do you understand and agree that you want to up or down vote tonight, not try to work with our staff?
Yes, I do. I mean, I believe the fact that we're going to remediate this significantly, even more than required by the county, I believe provides clear evidence that we intend on meeting our obligations under the law.
Okay.
Any other questions on this side? Yes, sir.
One quick one. You mentioned about the other reason for the tree, to come down is because of the driveway. Is it a permeable driveway or are you putting concrete driveway down?
It will probably be asphalt. We haven't decided that fully yet, though.
Okay. Because if it was permeable, it might be bumps and stuff, but it wouldn't tear up your driveway.
Yeah, up to after it crosses the easement, the water easement, it will be permeable. After that, it will probably be asphalt.
And then you said something about you did a lot of work on the driveway. Did you not know that the tree was problematic and just said, well, we're going to get a variance for it later anyway, and we can still go ahead and do the work on the driveway?
No, we hadn't had the property surveyed for the tree survey. Additionally, that is the highest point on the property. The rest of the property lies in a different flood zone.
Yeah.
We chose that spot because it was the highest part of the property.
Makes sense.
Now, I tell you, when I came onto that property, we could not see anything. We had to get rid of the sweet gums. My wife will tell you that she had to help me get rid of the little pine trees and the brush and everything else. So,
I understand. All right. Thank you, Mr. Chair.
Anyone else? Anyone else have a question? Thank you so very much for your testimony, sir. Do you have anyone else to speak in favor of this application? Do you have anyone else to speak in favor? Do we have anyone to speak in opposition? Do you have anyone to speak in opposition? Thank you. The case is closed to the public. Board members, do we have any questions of staff? Yes, sir.
So,
what question?
Mr. Foster, not to put you on the stand, but in your opinion, if changes were made to shift the driveway, shift the stairs slightly, is there a way to save this tree if a house is built in that location?
Without changing that driveway significantly, no. And by that, I mean, I don't see it. I'm not sure to move the driveway significantly, but I want that power line next to it. It is what, like the applicant said, it is a grass swamp. I found turtles in it. So there's nowhere that they could move that driveway to, unless they were to make the parking area in the middle of the driveway smaller, or do away with the parking area entirely. But I think the tree would still incur more root damage than it could handle. The grade changes alone, covering the roots with soil, the roots are going to suffocate under the soil. Tree wells don't work in the southeast. They get clogged, the drains get clogged full of sediment, and they back up. It had to change significantly to result in the tree living.
Okay. I mean, I get the placement of the house and why that location was chosen, so I appreciate that.
All right. So he said one of you if
I went through, but he was first.
I'm just trying to understand your thoughts, Mr. Foster, on where's wet around this tree? Because I see grades 11 and 10.
Right.
Kind of right in there, and 10.9, 10.7, 10. Where's this low point that you're worried about the change of grades of the driveway versus the tree? It seems like they would all be in that same grade range there, and I'm trying to understand where this wet area that you're talking about is
So
located.
it's to the north. So if they were to have that driveway curve farther away from the tree, towards the east, and then go farther north before coming back down again. So to give the tree more of its original grade, that would help the tree out. But to the north of that, and it's not shown on here, but I walked it, and the applicant also said the same thing. It is quite wet to the north of that. We just
Further, I'm just still seeing on this larger view when you zoom in a lot of 10s and 11s.
right. It doesn't capture all the smaller depressions there.
Oh, so it has a lot of lower
Yes,
things.
it's cattails. I found turtles in it. It's wet year round.
Oh, interesting. Okay.
Mr.
Thank you. Following up, Mr. Me.
Yeah, your turn.
Following up Mr. Nelson's question, he asked, I think specifically if you kept the driveway the same, but if you didn't keep the driveway the same and looked at another driveway proposal, then is there a way to keep the tree? And it sounded like you just made testimony to that.
Testimony that it could be done? Yeah, they'd have to lose the entire northern part of that driveway.
Yeah,
and
so-
make it just a one-side driveway to the south of the house.
The point that I'm making is that this is brought by their own actions. He did work on the driveway before. So all I'm trying to say is I think we should see other options, look at it, just for my vote from that standpoint. Thank you.
Since you walked the property, how many other Grand Oaks did you say?
I saw several.
10? Less than 10 more?
Possibly 10, maybe close to 15. Because when I walked the site, there's a chain on that at the beginning of the driveway. So I had to walk the whole way up there. But there's many more trees out there that will be grand trees within just a few years.
Any more questions for staff? Any more general discussion? Okay. At this time, I'd like to have a motion to either approve or deny this application. Would somebody be kind enough to help with that? All right.
I guess I'll take this one. This may or may not win. I'm actually compelled primarily by the drawing that the applicant provided that shows the canopy protection zone for this particular tree and the amount of the fact that canopy zone alone would require a variance that may or may not actually save that tree in order to put either the house there or the driveway there. I don't know if you guys recall that. So that's kind of the basis for the motion that I'm going to make. But in the matter of BZA 0526-00981, I am going to make a motion that we approve this request to remove a 35-inch red oak. I am making this motion because I believe it meets all of the criteria necessary to grant the request. That one, there are extraordinary and exceptional conditions pertaining to this particular piece of property. In particular, looking at the lot itself, the way that it's bisected by a drainage easement, and that dictating the location of the house, and in particular trying to place the house in an area where it's not in a flood zone is particularly important when building a house in the low country that close to the marsh. So I believe that we meet that criterion. That two, these conditions do not generally apply to other properties in the vicinity. Again, there probably are some properties somewhere with drainage easements that bisect them, but that does create a unique circumstance that dictates where a house could be built on this particular property. So we meet that criterion. For criterion 3, that because of these conditions, the application of this ordinance to this particular piece of property would effectively prohibit or unreasonably restrict utilization of the property. In meeting this criterion, again, I'm falling back to the flood zone that surrounds the house, a desire to have a driveway that circulates around the house, and the inability to have really any kind of driveway without some type of variance for that particular tree. And in this case, the an encroachment upon the canopy of that tree would not guarantee its survival just because of the grading that's going to need to be done to build a house in this location. So I believe we meet that criterion. For criterion 4, that the authorization of this variance will not be a substantial detriment to the adjacent property or to the public good. I think in this particular case, given the number of trees that are still present on the property that are or will be grand trees, the number of trees that the applicant is willing to plant, that actually helps us meet that criterion. For criterion 5, that the BZA will not grant a variance, the effect of which would be to allow a use that's not otherwise permitted. This is a residential lot with a residential purpose and a residential house, so we meet that criterion. For criterion 6, that the variance is not the result of the applicant's own actions. Again, for this one, I'm falling back to the configuration of the lot itself, the fact that it's bisected by this drainage easement, and that the highest point of land on which to build a property happens to be the same place that's occupied by this red oak tree, and that is what's driving the need for this particular variance. Of course, there may be ways to move things around, but it does not guarantee the tree's survival. Criterion 7, granting of the variance does not substantially conflict with the comprehensive plan or the purposes of the ordinance. Again, given the number of trees that are being protected on this property that will remain and those that will be planted, I believe that helps us meet this criterion as well. And I do recognize that even in a situation in which I was building a house, I had to remove a red oak, and we put that tree to good use, maybe not as lumber, but as firewood. And it was, it wasn't a grand tree, though, so I will take that. And in making my motion, I will include the 3 special conditions recommended by staff.
Okay, do I have a second?
Second.
Okay. Mrs. Sadell? Sadell, yeah. All right, any,
Discussion.
I see your hand, yes, sir.
Well, this may surprise some of you, since I usually have a heart attack when you mention Grand Oak. But I'm inclined to vote for this because our Mr. Foster said there's 10 or 15 already there and potential for many more. I'm willing to sacrifice 1 tree. But not for firewood, please.
Mr. Brown?
Is there any room in our abilities as a board to make a request? It's been stated that it's possible to, I guess, some kind of woodworking company or business. Can that be a part of the motion, or can that be anything we can put in there?
No.
I do appreciate the comment, Mr. Brown, but I think that might overstep our jurisdiction.
Yeah, I know. That's
slightly.
what I thought, but it would feel a lot better if I had some kind of guarantee on that.
That's it. That's why you.
Any more general discussion?
I should do that.
All right, I'll call for the vote at this time. All in favor, please indicate by saying aye and raise your right hand. Aye. Those opposed? 2. So it carries. Congratulations, sir. Your application has been approved. Within 10 days, you'll be getting information from staff letting you know the next steps in the process. Once again, congratulations and good night. Okay. So our next case is case BZA 05-26-00982.
They seem like honest people.
Ms. Carlisle.
Thank you.
Cal, 1 moment. Can I see you outside? Continue.
The applicant and property owner, Jeffrey Delavolpe of 59 Investments LLC, represented by Kenan Hoffman of Sea Island Homes, is requesting a special exception to establish a short-term rental property, extended home rental EHR at 601 and 603 Samat Street, TMS number 343-1500075 on James Island. The subject property and adjacent parcels are located within the low-density residential R4 zoning district. According to Charleston County records, the property contains a 2-bedroom single-family residence with a detached 1-bedroom accessory dwelling unit. The single-family home was built in 1955, while construction of the detached ADU was completed in 2025. The applicant proposes to operate the property as an extended home rental by offering 2 bedrooms in the single-family residence and 1 bedroom in the detached ADU, accommodating a maximum of 8 occupants and providing 7 on-site parking spaces. The 7 parking spaces are in the gravel grass driveway and yard. 7 spaces are required to meet the Charleston County's LDAR parking requirements, with 4 spaces allocated for the homeowner and 3 for the STR use. The property owner has indicated they will use Cialan Homes as the property manager. The location of the property, when looking at the county as a whole. This is the zoning ordinance section pertaining to STRs and the R4 low-density residential zoning district. The radius map, aerials of the property. We posted the property on June 26th. The single-family home and parking, and pictures of the ADU and parking. Adjacent properties, Samant Street, the site plan, tenant notice, and plat. Regarding the 3 approval criteria, staff stated that it may meet criteria 1 through 3. We received 3 public comments in opposition and 1 public comment in support of the request. The board may approve with conditions, or deny a case based on BZA's findings of fact, unless additional information is deemed necessary to make an informed decision. In the event the board decides to approve the application, it should consider the following conditions recommended by staff. 1, prior to zoning permit approval, the applicant shall complete the STRP limited site plan review process. 2, the use shall comply with all requirements of Article 6.8. 3, the property owner shall be responsible for ensuring that tenants comply with the Charleston County noise ordinance. 4, the total number of rental days for the property shall not exceed 144 days in aggregate per calendar year. This limit applies to the entire property collectively. 5, prior to zoning permit approval for the STRP use, the applicant shall obtain all required permits and approvals for the detached ADU. 6, a building safety inspection may be required for the use of the living room within the single-family residence as a sleeping area, if required. The inspection shall be completed and any necessary corrections made prior to the issuance of the STRP permit. Any questions?
Mr. Brown?
I see 7 parking spaces, but I don't see how parking space 1, 2, or 3 can get out of their parking space if 4, 5, 6, or 4 or 5 at least are in place. Has there been any kind of review of this actually works? I mean, I know it shows spaces, but has anybody in site planning review looked at this
Functionality.
and see about functionality? Does it actually function? Because it doesn't, as shown.
You know, for us, it's do they have enough space for the required number of spaces? You know, these spaces are 9 foot by 18 foot. You know, most vehicles are not 9 foot by 18. So there is some, leeway there. And the hope is, of course, is that people can figure it out. But in a prior case this evening, y'all talked about parking issues and maybe things the owner and applicant can do to help mitigate that. So,
And one more question is
Sure.
this, do we have any kind of requirements as far as, see if I can word this right, whether this is 1 rental or 2, like 2 separate tenants coming in or whatever over a weekend, or is this?
So technically, yeah, sure. They could rent out the main home and the ADU to separate parties. Would be one permit, but the number of days, the 144,
Okay, so they're
would
two-
apply to the whole property. So nights in either dwelling would count to the 144.
I mean, it's probably a question for the applicant anyway, but sure. Thank you.
Any other questions? Yes, sir.
Just a couple, and I always go through the same things. But first of all, if the living room in this case is not counted as a bedroom, what is the maximum number that this application would accommodate?
So, they're asking for, just bear with me a second here.
I count 6 instead of 8. I mean, we're
Right.
We're
So-
basically calling living room a bedroom for these purposes.
Yeah, let me.
The septic or are they on sewer?
That'd be a question for the applicant.
Okay.
Trash.
Trash.
And this has the breakdown for the occupants per room. Yeah. And then
Okay. You've already answered my question about parking. How about trash? Is this something is it customarily picked up? Do they have to dispose of it? How is that handled?
It's up to the applicant, and they can answer that question.
Okay.
Very good.
That's it.
Very good. All right. I think it's you, young lady. We've got this auditorium about empty. So name and address, please.
Thank God for that. Kenan Hoffman. I live at 5916 Arbor Road in Hanahan, representing Jeff Della Volpe. I'm VP of Sea Island Homes. To go ahead and answer the questions real quick. So this property is actually fenced off completely, each unit. They have their own access points, so it can be safely rented without interference. We do have a contracted trash guy. It's actually 3 college students that have been doing all of our Folly, James Island, and Johns Island properties for about 2 or 3 years now. For the parking, like he had said, we just have to prove the parking, but I have already made it very clear in my listing that you are only allotted this spot, park here directly how it is supposed to be parked. That way we don't have anybody blocking someone else in for the other unit. We also make it very clear that there is no street parking or parking outside of the gravel area because I don't want it to look like a used car lot. And also for the questions about occupancy, there was just a bit of confusion from the homeowner. He is in Texas, bought it. His teenage children are wanting to go to COC, and he wanted something close for them to live in, but they're still in high school, so kind of a preemptive buy. He was not aware, I guess. His wife did a lot of the purchasing, and I did all of the outfitting, building of it. I told them technically 5 because there is a fold-out couch in the main house, but really a 6 occupancy kind of thing, just 2 in the studio, ADU, and then there's a double twin trundle in one bedroom and a queen in the other. There is the pull-out couch, but that's usually like a half of the occupancy, in my opinion. It's up to the discretion of the Airbnb guests. But, yes. Sorry, I have lost all the rehearsed everything I had today. I've learned a lot about trees, though.
Did you say septic or sewer?
It is sewer. Yes, sewer. Called our plumber today to confirm.
What questions do you have?
I had just a couple. I wouldn't have trouble with 6. I have trouble with 8 that I'm trying to get over. I want to talk about the living room being called, essentially being called a bedroom. I want to talk to you about the living room. Is it a pull-out couch? Is it a couch? Is it an air mattress?
So
is there
it is
furniture? Is there a place to put clothes, or is it going to be a common area?
It's a common area. It's a living room.
Okay.
It does have a little trundle-style pull-out from under the futon.
Okay.
It's like a miniature L futon. I personally couldn't fit on it to sleep. I am kind of tall. But my daughter could. She's 7.
Okay.
But no, I am typically our permit application person. He did the application himself. I would not have included that as a
I appreciate your presentation and appreciate your honesty.
Absolutely.
It makes it more difficult when we're going to, for me at least, and I know what I think council's getting ready to do. They haven't done it yet, but when we call, I have a problem, and I know one of my colleagues has a problem when not you in particular, but when people say, well, I'm going to call my living room a bedroom, and I'm going to call my dining room a bedroom, and all of a sudden we got 10 people in a place with maybe 2 bedrooms. It's a problem for me. I wouldn't have the same problem if you were seeking 6 rather than 8.
Yes, 6 is totally fine on our end. Again,
There you
he
go.
submitted it before asking for my approval on should we do that. I'm the no person at the company, so when they try to do the whole living room is this
So you're
kitchen,
seeking 6 instead of 8 now? Is
yes.
that-
I would be happy to amend to 6. I already told him on the phone on the way here. I was like, I'm going to tell him 6.
All right, thank you.
So,
Mr. Brown?
This goes back to my parking function question.
It's less now.
Yeah, I know. How many fewer parking spaces are required now? Is a question one.
Well, it's still the same requirement.
Still the same number. All right. So, have you? You said
just because it's required, I will
Sure.
not be allowing
that many.
We will not be. So for the studio, typically we only really allow 1 car, provided space for them, and strict no street parking. Now, if they're booking both of them, sure, play Jenga with your cars, but you are only allowed to bring 4. But I do go out there and put up signs and make sure this is for this unit. Park, and I drew the little tenant notice. I'll draw out this is how the angle of your car needs to be. Do not block it. If you have a large truck, this is probably not the property for you to book. I like to do a lot of preventative.
Yeah, makes sense.
Yes.
All right. Well,
I'm fine.
I'm fine with it. Yeah. If you can make it function, then.
And the same goes for the noise ordinances and any events or parties. Under no circumstance do we allow any form of partying, events, anything at any of our properties. We have roughly about 150, and I have personally permitted 47 of them in the North Charleston area. Tanya loves me, and I love her. She's a great human being. But I am very familiar with all of the, my listings read kind of crudely sometimes of, no, you're not allowed to have fun. Please just sleep here and leave. But I am very strict on my entire team to make sure that we do not open that door at all. And we are all within 15 to 30 minutes. We're all completely local, about 5 or 6 of us. And I also, once we get our permits, go and hand my business card personally to all of the surrounding neighbors. Just because, trash gets missed, parking gets messed up, and God forbid there is a party. I like to be preventative.
Any more questions? Mr. Jordan?
So when things do go out of hand, who are they going to call at 3 a.m. for help? But do they know that? Does the neighbors know that you're the one?
Mm-hmm. It has my name and number on it.
So are you or your recorder going to answer at 3 a.m.?
It'll be me. It might be the second call, and I do warn them. It might need to go through twice. I do have a 7-year-old, so I'm very tired. But as long as you call twice, I promise you I'll pick it up on the second one.
At 3 a.m.?
Yes, unfortunately. Nature of the job. Also, I have younger siblings.
Okay.
And they do that a lot.
Sounds like you're running this company.
It
sounds like you're running this company.
I am VP of operations, yes.
That's meant as a compliment.
Thank you.
What's the name of the company?
Sea Island Homes.
Okay, that's what I thought.
Any more questions? No. Thank you so very much for your testimony.
Absolutely.
All right. So at this time, this case is closed to the public. Board members, do we have any questions of staff? We have any general? I got one question. So the ADU, does that require one or two vehicles?
Well, the number of spaces is 3 for the ADU.
Okay, that answers. Any other questions of staff? General discussion. Very good. So I need a motion at this time. Yes, sir. I got your eye.
Thank you, Mr. Chairman. I'm prepared to make a motion to approve the request for a special exception. This is governed. This request is governed by Article 6.8, short-term rentals, and Section 6.8.2, the permitting process. Jurisdiction is proper. A compelling argument has been made to approve. The criteria are set forth in 6.8.2C1 through 3. This is compatible with existing uses in the vicinity, will not adversely affect the general welfare or character of the immediate community, especially given, and my motion is made subject to the provision that this is going to be for 6, not for 8. And I would also like to say it would be subject to the conditions recommended by, the 6 conditions recommended by staff. Number 2, adequate provision has been made and shown to have been made that exists for setbacks, buffering, landscaping to protect adjacent properties for noise, traffic congestion, and similar factors. Number 3, this complies with all applicable rules, laws, and standards of the ordinance, including but not limited to any conditions, zoning district standards, and applicable short-term rental site plan review requirements. So that is my motion.
Thank you. Do I have a second? Ms. Smith? Ms. Smith with the second. Any discussion? All those in favor, please indicate by saying aye and raise your right hand. Aye. It looks unanimous. Thank you. Congratulations. Your application has been approved. Within 10 days, you'll be getting information from our staff letting you know the next steps in the process. Drive safely and have a good night, and thank you. Very good. Our last case for tonight. Woohoo! Case BZA 0526-00983. Mr. Carlisle.
Thank you. The applicant and property owner, Ron Moran of MI2 LLC, is requesting a special exception to establish a short-term rental property, extended home rental, EHR at 1627 Widgeon Lane, TMS number 331070081 on James Island. The subject property and adjacent parcels are located within the low-density manufactured housing subdivision MHS zoning district. According to Charleston County records, the property contains a single-family residence constructed in 2025. The applicant proposes to operate the property as an extended home rental by offering 4 bedrooms, accommodating a maximum of 10 occupants, and providing 6 on-site parking spaces in compliance with the ZELDAR. The property is not owner-occupied, and the property owner has indicated they will manage the rental operations. Location of the property within the county as a whole. This is the zoning ordinance section pertaining to STRs in the low-density manufactured housing subdivision, MHS zoning district. The radius map. Aerials of the property. Property was posted on June 26th. This is a picture of the residence and parking. Adjacent properties, Widgeon Lane site plan, and the tenant notice, recorded plat. Regarding the 3 approval criteria, staff stated that it may meet criteria 1 through 3. There were 3 public comments in opposition to this request. The board may approve with conditions, or deny a case based on the BZA's findings of facts unless additional information is deemed necessary to make an informed decision. In the event the board decides to approve the application, it should consider the following conditions recommended by staff 1, prior to zoning permit approval, the applicant shall complete the STRP limited site plan review process. 2, the use shall comply with all requirements of Article 6.8. 3, the total number of rental days for the property shall not exceed 144 days in aggregate per calendar year. This limit applies to the entire property collectively. 4, the property owner shall be responsible for ensuring that tenants comply with the Charleston County Noise Ordinance. 5, the maximum occupancy for the short-term rental property use shall not exceed 10 occupants at any time. And 6, the 4 parking spaces located under the house shall remain clear and available for use by STRP guests. Any questions?
Any questions so far?
Not for staff.
Thank you, sir. Thank you, Mr. Carlisle. Yes, sir, it's your turn.
Hello, everyone. My name is Eran Maron. Live in 2245 Portside Way in Charleston, South Carolina, 29407. The property we're talking about today, 1627 Widgeon Lane. It was newly built. It's 4 bedrooms, 2,000 square feet. It's a raised home. It's fenced in the back on one side. It's in the riverfront community right before Folly Beach, a couple miles before. We self-manage all our properties, and we always vet our guests. We only use really VRBO and Airbnb, which do that too. Do a pretty good job with that. We maintain a 5-star reviews across the board for all the properties. We don't allow any events in our properties. We're very strict about that. We have a lot of inquiries regarding micro weddings and different little get-togethers, and we shut it down right away. We say no. We always order, I know there's a lot of questions about trash. We always order 2 trash cans. And a lot of times we send an automated message a day before if they can roll it to the curb, but we kind of go around and make sure they did, and if they didn't, we do it ourselves. So there's never an issue with that. This specific property, I talked to the neighbor next door. It's an older gentleman. That's the guy who lives in the trailer on the right side. And the family across the street, I actually know them. She used to work for me in one of my restaurants in my older life, my previous life. And that's it. This will be occupied for up to 40% of the year. So nobody else is going to occupy that for the rest of the year. That's pretty much all I have. If you have any questions.
Yes, sir.
Thank you, Mr. Chair. Can you go, I think, I need the layout plan of the floor plan. I think it's the next page. Yeah, that's it. So thank you for your presentation. I'm struggling slightly, not much, with the 4 bedrooms for 10 people. So if you can help me identify, because they're not labeled bedroom 1, 2, 3, 4, trying to understand which bedroom is so much larger that you can get 4 people out of it. And 10 people out of a 2,000 square foot house is a lot of people. You got plenty of driveways, but it's just a lot of people.
So all the other houses that we previously came for, all were approved for 10 people, same square footage. The bedrooms were big. So there's always a bedroom that is like a frog.
Okay, that's what I'm asking. Can you identify based on this?
Same situation here.
Your display does not have it labeled.
Yeah, it's hard for me to see from here. Do you see from here which one? Bottom left? Okay, it's the bottom left bedroom.
Bottom left bedroom is the one you will put 4 people in?
There's 2 king beds there, yeah.
Huh?
There's 2 king beds, just to show you the size of the bedroom.
That looks like the smallest bedroom.
Is that the one? The one on the left? It's hard for me to see.
10's a lot for me. That's all. I'm fine. Thank you, Mr. Chair.
Anyone?
This is the bedroom kind of door entrance to this whole. That's the bathroom, and this is the.
Yeah, that's the master. That's the master, yeah.
Thank you.
Any other questions? Mr. Jordan.
Well, I was going to ask my colleague's question, but I'll let him ask it. So how about my 3 a.m. question?
We live here, no problem. I live in West Ashley, my stepdaughter in James Island.
You're the contact person?
Yeah.
Are you going to answer your recorder?
No, we answer. I had 3 restaurants in Charleston, and I had a couple of times we had break-ins on James Island. I got a call from the sheriff at 3 in the morning, and I went to the restaurant.
How close? How long did it take you to get to the place?
20 minutes from me from West Ashley, but she's closer. She's like 5 minutes.
All right, I assume he's going to ask you his usual question. Go ahead, sir.
Oh, okay, Ms. Smith.
You don't know?
I'll give him a chance. Oh, he's good.
I'm going to make a little bit of a big deal about these drawings because I know we'll see you next month.
No.
So can we get these labeled properly so we
Absolutely.
can make sense of?
Yes.
I can't tell how you get into these 2 bedrooms. There's it shows a bathroom in between them and how to get 2 arrows going to what looks like the bathroom.
You talking
But
about
how
the
do you
top,
get out?
The top picture?
Yeah.
So there's that's like a hole to get in. There's a bathroom right in front of you, and there's a door to the left and a door to the right.
Thank you.
Yeah, sorry.
Yes, sir.
Are you open to going to 8 instead of 10?
Ideally not. It's going to be hard
Ideally
for
not.
us to compete.
Is that,
with,
that wasn't a no. Is that a yes or no?
A no. Yeah.
A no. Okay, thank you.
All right.
I have a question.
Yes, sir.
All right, thank you. What size is your septic tank?
We don't have septic.
You're on
Sewer.
Okay, you're on sewer?
Yeah.
Okay, you checked that one off. I want to go to trash, because I see that as, I'm in short-term rental hell.
I know.
By some accounts. The short-term rentals, they leave on Sunday. Trash is picked up on Tuesday. They might take it out, they might not. They're not going to take it out like everybody who lives there the night before gets. Who's going to take it out if they take it out on Monday? They're not going to take it out on Monday because they're gone. Who's going to take it back in, or is it going to stay on the street?
The trash team is right here.
What most people do is they contract with somebody to bring it in.
So most people, we send them an automatic message to the day before,
Yeah.
according to the day. So most people, they're fine. They take it out, but we end up making sure that it happens. And a few times we had to take it out, but we do it.
Not directed at you in particular, but it's a problem when people leave on Sunday and
I
they
know.
might take out the trash, they might not, and they're clearly not going to bring it back in. So I looked at your notice, and you seem to put it on the tenant, or the short-term rental, to take it in, but that's not workable. How are you going to make it work for us?
So there's a notice at the house. There's an automatic message that comes through the channel. If it's Airbnb or VRBO, they get a message 24 hours before. And we also do it. That's what I'm saying. We actually drive and pull it. I did it yesterday.
Okay.
Yeah, I pulled recycling. She pulled trash. Yeah,
So
we
in
make
the-
sure to do it. Otherwise, we're in big problem with the trash.
So in the example that I was giving you, where the short-term rental leaves on Sunday, and the trash pickup is on Wednesday, you would come and see that it's picked up on Wednesday, and then after trash
Yeah,
pickup
so like
on
James
Wednesday,
Island, usually
you take it back in.
a couple of houses is Monday, a couple of houses Tuesday. So we make sure we do it if the guest didn't do it.
Okay. One last question on
Yeah.
the bedroom with 4 people. How big is it? I'm trying to get the dimensions, but that's putting a lot of people. Are they bunk beds or what?
No. 2 king beds. There's size for 2 king beds across
How
from each other.
big's the room?
So it's really long, and it's not too wide, but there's room for 2 king beds across from each other.
So how big is the room? Square footage wise.
Yeah, I wouldn't know. I mean, I don't.
Compared to
But just the fact you can fit 2 king beds tells you it's a pretty big room. Otherwise, you wouldn't be able to fit it.
Do you have any photographs of it that would? If I want to help, I want you to help me. Do you have photographs that can show how many beds are
Do
in
we
there?
have any photographs? Or we're trying to look. I don't know if we have
Okay.
it, but it's you walk in basically, and there's a bed on the left, a king size bed on the left, and a king size bed across from it on the right.
Okay. Well, I mean, I'm willing to wait so you can show me the pictures. And,
Sure.
I'm one of these believers, trust but verify
Yeah,
kind of
no
people.
problem.
But I am having problems getting 10, I've got to tell you frankly, like my colleague, I'm having trouble with 10, but if you can show me this, this might help.
Can we work on it?
So I take it, you have it.
Throw it?
No, wouldn't dare do that.
I will say that most times it's not 10 people come.
Okay.
It's rare that 10 come, but then you want, in order to be competitive with everyone else, you need to
Okay.
Yeah, it's kind of like the best we have.
King size beds and 10 by 10.
You don't like it, you don't have to fit it in the width, and then the room's so long, there's room
Yeah.
in between two beds.
120 square.
It's gonna be a fairly tight fit.
Yeah.
Make the motion for 8. If it doesn't matter.
All right, I'll make a motion for 8.
If you don't like it, you're not taking it.
Thank you.
Yeah. Can we shrink it up so I can see how?
That's
She
it.
said they couldn't, that's it.
That's it.
She said that's it. That's the only picture she had. She was taking a picture of it.
We should have them lay down.
Okay.
They can play feetsies with each other, I guess.
Let's go to the house. Oh, look at the room, they're back to back. Oh, that just made it worse. Yeah. I'm fine, I can see it from here, thank you.
Okay.
Yeah.
All right. I think that should answer all the questions that we have at this time. All right.
Can I ask our counsel, can I make a motion for 8 versus 10, or does he have to, or are we voting up and down on 10?
You can make it for anything you want if you make this.
All right.
vote.
Okay. That's what I
Motion. Okay. Thank you so very much for your testimony today. Since there's nobody else in here, I take it there's no more room for anyone else to say anything, either to support or deny, correct? So at this time, this case is closed to the public. Board members, do we have any question of staff? Do we have any general question at 8:01? All right. So since we have no question of staff and their general discussion, at this time, I'd like to ask for a motion. I think you're biting at the bit, ready to get at it.
I'm ready.
Let's see what you got to say.
Ready
my
to go.
friend.
The applicant may not like it, but I'm prepared to make a motion to approve the request limited to 8, not 10. If it's going to be 10, I'm going to be opposed. It'd be subject to the recommendations made by staff, again, limited to 8. My reasoning is that this approval criteria is set forth in section 6.8.2C, article 6.8, short-term rentals, and 6.8.2, permitting process and special exceptions. An excellent presentation has been made dealing with item number 1 criteria. It's compatible with the existing uses in the vicinity and will not adversely affect the general welfare. I've seen the photographs, I've seen the parking space, but I've also looked at the size of the house, and I didn't see any evidence that there was anything else. There may have been. I may be misunderstood, but I didn't hear any indication that there had been 10 for others in the immediate vicinity. So I would make my motion to limit it to 8. Adequate provision is made under criteria number 2 for setbacks, buffering, fencing. We're familiar with the applicant, and he does a very good job in monitoring his properties. He's made a provision for trash. He's made it's on septic versus sewer, so there's not a problem there. You've got four bedrooms that appear to accommodate 8 people. Under criteria 3, it appears to comply with the applicable rules, regulations, laws, and standards of the ordinance, including but not limited to conditions, zoning standards, and applicable site review. So that is my motion, again, subject to the recommendations made by staff.
Very good. We have a motion that's on the floor. Do we have a second?
Second.
All right, we have a motion that's been seconded. Any question or discussion? Mr. Neal?
Mr. Nelson. I'll say in this one, I find that limiting this one to 8 is kind of arbitrary compared to what we've done recently, but I'm not going to follow my sword over this one. But that's just my opinion.
Any other discussion? I have the same viewpoint as Mr. Nelson. Well, they asked for...
They asked for 10. We've had no... well, there was some opposition that was written in, mainly due to the fact that there have been a number of STRs approved in this particular neighborhood. But we've had no testimony against whether or not 10 people for 144 days is detrimental to that neighborhood. So I think it's just a...
Might be who's in the house with all that snoring going on.
It could be. It could be. I also think that when you get into the Airbnb and VRBO world, the review system actually does a pretty adequate job of driving people to make a decision if they want to stay in that particular house or not. And so if there's a listing for 10 people, and I use a lot of Airbnb, so that's why I say this, but if there's a listing for a home that says 10 people and a group has been there that had 10 people there and they were dissatisfied with the accommodations, they would post that. And it would kind of be a self-fixing situation just based upon the reviews alone. But that's my opinion.
I'd respond by saying that I considered, among other things, the size. It wasn't an arbitrary decision. I looked at the size of the rooms, the layout of the property, and the fact that there was opposition in this case that was I found to be credible.
What opposition did you find?
There are 3 people that have written
letters,
comments in opposition.
I guess what I should have said, did you see anything that would relate to the amount of people that was in the letter of opposition? Because I'm like Brother Nelson, is that the people that actually stay in these places, they actually make a rating on how well this thing is done and operated, and they make the choice if they want to put 10 or 8 people in there. I just think limiting this particular application won't be, beneficial to the whole Airbnb and short-term rental process. I'd like to see if you guys wouldn't mind amending your motion back to the request that is there. Mr. Brown?
Just in line with that same thinking, and I can't say it's been for every one where we've maybe limited the number of people, but typically it's been where they've used a living room or a dining room or some other thing as the justification to limit it, because it's not a bedroom. But in this case, it's a bedroom, and I worry that it's a bit arbitrary, I guess.
Yes, sir.
So my philosophy on these are two-pronged. One, is it owner-occupied, and is it not owner-occupied? And I feel strongly that when you get these type of operations in neighborhoods, when you get up to 10 people, I feel it's more of a commercial impact than standard, you're just renting out a room or two. So I think the number that gets closer to 10 makes it more like a hotel. If it was a 5-bedroom and the owner was living there and we're going to rent out 4 bedrooms and wanted to do it, then I think it's not as much of a commercial entity as it is when it's not somebody there all the time. So that's where I'm not being arbitrary. It just happens to be this one. It's because there was already negative input from homeowners that say, hey, we don't want this in here. Granted, it's only 3 and it's a very, very large neighborhood. And I know this is a good operator. I know that I've heard the testimony that he's done. So it's not that, it's just the actual impact to the neighborhood. I think we start impacting a little bit more. And that's where my vote is. It's not just this one application. That's the theory that I have all the time. The more people you put in there, and if it's not owner occupied, I start having more problems with it. So that's just where I'm.
I guess in my point, I use Airbnb a lot I wouldn't want an owner in there when I'm
I
in a
understand.
place.
No, I understand that
Yeah.
completely, but that's usually that's the smaller ones.
Yeah.
The bigger ones are the issues, for me.
Okay.
One more thing, if I could add in, all of us are aware of the laws and the preamble, and that we want to provide housing for working people and families. And each time we put a mini hotel in a community, we're taking away from families and working people having housing, and that's an additional reason why I'm concerned about many mansions, many hotels. It takes too much away from working people and away from families, and that is also part of my reasoning. People could disagree, but that's my thinking is we need to be as concerned about protecting our community and our children and our families and working people and allowing them to have houses. And each time we put one of these things into a community, there's nowhere for working people to live anymore.
Well,
So that's part of my reason.
And is it a single-family neighborhood at that point? I ask you. At that point you're talking about, is it still a single-family home neighborhood? I don't think so.
Yeah, there's also the flip side of that, which is if a neighborhood needs investment and as property values go up and up and up, it's really expensive to finance construction. And so this can actually help increase the supply of housing. This may not be an Airbnb forever. It's a neighborhood that's changing. It's a larger house on the property that may not have been able to pencil out if it weren't for something like Airbnb.
Any other? Yes, sir, Mr.
That's
George.
true what you said, but in essence, you're providing home care facilities for out-of-town people, not the people here that live in this area that need it.
Well, I'd like to say we all need housing. Everybody needs housing.
But we represent Charleston County.
Absolutely. And we can probably go on this all day.
No, we can't.
No, yeah, I know, we can't. We're not going to do it. But one last.
If this motion is defeated, then another motion can be made to go back to the original.
Yes, yes.
I just want to make sure.
So at this time, let's bring it to a vote. All those in favor of the motion that's on the floor, please indicate by saying aye and raising your right hand. Okay. Those opposed? Okay. So that motion failed. Can I get a motion to approve or a different motion altogether?
Mr. Chair, if I can get back to that screen really quick, I'll make a motion. Sorry.
Here's mine.
I got it right here. All right, in the matter of BZA 0526000983, I would make a motion that we approve this request. In making this motion, I recognize that we meet the three criteria necessary to grant this special exception. That one, it is compatible with existing uses in the vicinity and will not adversely affect the general welfare and character of the community. And in this particular case, we have an applicant that's coming here with several before us, and to the best of my knowledge, has not received complaints within the county for the SDRs that he is operating. And thus, I believe we meet that criterion, that it does not adversely affect the community, that adequate provisions have been made and exist for such items as setback, buffering, et cetera, to protect the adjacent properties. And I think in particular here, the applicant's lengthy explanation about how they handle trash at their property to make sure that it is properly taken care of speaks volumes toward the provisions that he's made to limit impacts to the neighbors, and that for criterion 3, it complies with all applicable rules, regulations, and laws of this ordinance. Again, I think that one's fairly self-explanatory in how it meets that criterion. So in making this motion, I would include all 6 of the special conditions recommended by staff.
Okay. Do I have a second? Mr. Brown? All right. Any discussion about this one? Very good. All those in favor, please indicate by saying aye and raise your right hand. Aye. Any opposed? Those 2, it carries. Within 10 days, you'll be getting information from staff, letting you know the next steps in the process, and you'll be getting information from the staff, of course. Otherwise, thank you so very much. Good night. Drive safely. Ms. Working. What do we have next?
Well, I'm happy to report we only have 8 cases. Woo! Wow. It feels like a break. Only having 8. So. Yes. And we
Anything
don't,
else?
And September is not full yet, so that's.
So I would like to say one thing quickly. I noticed that the ordinance has changed for STR for anything over 10, if you hadn't read that.
It's not an ordinance change, it's International Building Code.
Yeah.
Which,
Okay.
it has not changed, it's just, they've told us how they want us to
Okay.
communicate that.
Well, thank you. Means
Yeah.
adjourned.
Good work, team, for y'all.
All right.
Get back to us.
Have a good evening. Yep, always conduct a good meeting.
Oh, yes, sir. Thank you.